open this public hearing of the Legal and Constitutional Affairs Legislation Committee inquiry into the provisions of the Freedom of Information Amendment Bill 2025. I'd like to begin by acknowledging the traditional custodians of the lands on which we meet today, and I pay my respects to their ancestors and elders past and present. I extend this respect to all Aboriginal and Torres Strait Islander peoples and their cultural and spiritual connections to Australia's lands and waters. On behalf of the committee, I welcome any traditional owners that are here today. For people participating remotely, I'm the chair of the committee, Senator Jana Stewart. Also joining me here today, Senators Jessica Collins, Senator Dorinda Cox, Senator Varun Ghosh, Senator David Shoebridge. I understand Senator Pocock might be joining us in the room. We've got Senator Jackie Lambie as well with us online. I remind senators of their obligations under the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. As chair, I'll be particularly vigilant in ensuring the cultural safety of First Nations people and culturally and racially marginalised groups during these proceedings. I remind witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to the committee. The committee prefers evidence to be given in public, but under the Senate's resolutions, witnesses have the right to request to be heard in confidence, described as being in camera. If you're a witness today and intend to request to give evidence in camera, please bring this to the attention of the Secretariat as soon as possible. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer, having regard to the ground on which it is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Such a request may, of course, also be made at any other time. A witness speaking for the first time should state their full name and the capacity in which they appear, and witnesses should speak clearly and into the microphones to assist Hansard to record the proceedings throughout the day. Now that's my long spiel done. And I now welcome representatives from Transparency International Australia and the Australia Institute. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege has been provided to you and is available from the Secretariat today as well. For the Hansard record, would you please state your full name and the capacity in which you're here today? And we can start with Transparency International Australia.
My name is Hansika Bagani and I'm appearing for Transparency International Australia.
Thank you.
Bill Brown, Director of the Australia Institute's Democracy and Accountability Program.
Sky Predovec, Researcher at the Australia Institute.
Thank you very much. Would either of you like to make an opening statement? Or both of you, perhaps?
Yes, we would.
Great, we'll start in the room.
Awesome.
Thanks very much.
Thanks for the opportunity to appear before the committee today. This bill is a solution looking for a problem, and despite looking far and wide, it hasn't found one. It's true that the FOI system is broken. Only 21% of requests are granted in full, compared to 81% in 2007. But because of this heightened scrutiny, the cost per determined FOI has skyrocketed, even while the number of determinations has fallen. It took over $4,000 on average to determine one FOI request last year, compared to just $1,200, inflation adjusted, in 2007. Determinations now take 51 hours on average, more than triple the 13 hours it took in 2007. Time is spent denying access rather than facilitating it. But this bill doesn't seek to address those problems, which are mainly cultural and come from the top down. Instead, the government has justified these changes on the basis that the E-Safety Commission has been unduly burdened by FOI requests and a supposed system-wide glut of auto-generated requests. But there is no concrete evidence for either of those. Even with the system's issues, only the equivalent of 544 full-time staff work on FOI. That's less than half of 1% of the Australian public service. A small price to pay for a transparent and open democracy. What this bill would do is make it harder and more expensive for Australians to get information from the government. The proposed 40-hour cap is unnecessary, and it would reward inefficiency and stonewalling. Introducing fees would recover only a tiny fraction of the system's costs while restricting the public's ability to access information. The Robodebt Royal Commission recommended that Section 34 of the FOI Act, which deals with confidentiality of cabinet documents, be abolished because it was routinely abused by public servants as an excuse to refuse FOI requests. This bill would do the exact opposite, tightening Section 34 and making it even harder to access documents. FOI is not perfect, but this bill would make its issues much, much worse. Government secrecy is the main cause of problems in the FOI system, not the applicants who would be penalised and further restricted under these changes. Thank you.
You're on mute, Chair.
That helps. Ms Begani, have you got an opening statement you would like to make?
Yes, we do. Thank you. Chair and members of the committee, thank you for the opportunity to appear today. My name is Hansika, representing Transparency International Australia. Our CEO, Clancy Moore, was unfortunately unable to be here today due to some urgent matters. I'm happy to speak to the key areas of TI Australia's submission, and I may need to take other questions on notice. Our submission notes that freedom of information is a cornerstone of democratic accountability and a proven corruption prevention tool. Under Article 13 of the UN Convention Against Corruption, Australia has committed to guarantee effective access to information, enable public participation in decision-making, and protect the freedom to seek and publish information about corruption. Access to information also features in 3 of the 13 data sources that inform Transparency International's Corruption Perceptions Index, the most widely referenced gauge of public sector corruption risk. Plainly put, strong FOI laws are both part of our international duty and our best defence against corruption. But Australia's FOI system is in serious decline. Grant rates have fallen, refusals have risen, and reviews take too long. Behind those numbers and trends are delayed stories, stalled research, and the public left in the dark. This is not for lack of warnings. The 2013 Hawke Review called for a comprehensive look at the FOI framework. A decade later, the Senate Legal and Constitutional Affairs References Committee's 2023 report identified systemic underperformance, delays, and a culture of secrecy. The Robodebt Royal Commission report cautioned against the misuse of cabinet confidentiality as a shield from scrutiny and urged a more principled public interest-based approach. The message has been consistent over many years. The system needs real reform. We welcome the government's momentum to modernise freedom of information. Attorney General Rowland, in her announcement of the reform, said the current laws are not working well for anybody. We agree, and as no doubt you'll hear throughout the course of the day, and as is present in so many submissions to this committee, so do many users, civil society organisations and the public service. But as drafted, this bill risks entrenching secrecy, slowing access and creating new barriers to accountability. I'll highlight just a couple of our key concerns. First, an application fee for FOI requests would cut against the FOI Act's current objectives. We believe fees would deter engagement, especially by journalists, researchers and civil society, and they rarely cover costs, even the cost of administering the fee itself. So a fee that is high enough to fund the system would be prohibitive, whereas a modest fee would mostly function as a deterrent. Second, on the issue of banning anonymous requests, there may be many reasons people make an anonymous request, including protecting their safety, privacy or employment, seeking sensitive records without re-traumatisation, and crucially enabling potential whistleblowers to lawfully obtain documents needed to make a public interest disclosure. Restricting anonymity would silence vulnerable applicants and those considering disclosures for fear of retaliation. Third, the proposed 40-hour processing cap risks becoming an easy ground to refuse complex but important requests. the very matters where transparency is most needed. Fourth, the approach to cabinet confidentiality appears to widen, not narrow, an already overused exemption. We should not move away from a rigorous public interest test, and cabinet confidentiality must protect collective responsibility, not conceal wrongdoing or poor administration. In contrast, in late 2018, New Zealand's cabinet formalised a commitment to proactively release its materials. Cabinet ministers are responsible for releasing papers and decisions within 30 business days of finalising cabinet decisions. As it stands, this bill is too flawed to proceed. The problems it seeks to address are real, but the solutions should be developed through an independent, comprehensive review with public consultation. There's also the practical step the government can adopt now ahead of any review, which is requiring proactive release of commonly requested information. International practice shows this works. Ministerial diaries disclosure can reduce FOI demand and it builds trust. Finally, on cost, a lot is made of the price of running the FOI system, but the far greater cost is secrecy. When accountability mechanisms fail, the consequences are profound, as robo-debt demonstrated, harming hundreds of thousands of Australians and ultimately costing billions, alongside immeasurable damage to public trust. Investing in an accessible, fair and efficient FOI system should not be seen as a budget burden. The cost savings that would be incurred by exposing failures of bad governance would far outweigh the cost of administering a fair system. FOI is a fundamental right. Australians deserve a system that works, one that enables them to know what the government is doing in their name. Thank you. I'm happy to expand on key areas of our submission and, where needed, take other questions on notice. Thank you.
Thank you very much. Before we proceed to questions, I understand there's media in the room this morning. I'm just putting to the committee to see if there's any objections, and I will take that as a no. Thank you very much. And given the short amount of time that we've got, we'll proceed in 5-minute blocks of time because we've only got this panel until 11:30. And I'll go to Senator Collins and Senator Shoebridge after that.
Thank you, Chair. Thank you so much to both of you for your frank evidence today. My questions are for Ms. Pagani at Transparency International. Do you consider the bill should be passed in its current form?
Sorry about that. I'm on mute again. No, we don't believe the bill should pass in its current form. If the bill passes as it is, access will get harder and slower. The issue of application fees, it will put off the people we want using FOI, like journalists and researchers and community groups, and it will raise very little money. Cutting off, banning anonymous requests or pseudonymous requests will make potential whistleblowers think twice. Because they won't be able to check the documents they need safely before making their disclosure, and that hard 40-hour cap will become an easy way to refuse complex matters that are clearly in the public interest. Broadening cabinet confidentiality, as we said, will hide more factual material, so major programs and big spending face less public scrutiny. So the impact of this would be more refusals, more partial releases, more legal disputes. We believe reviews will take longer and the backlog at the OAIC will actually grow. Costs will rise. This is not a cost-effective solution for the FOI system because the agencies will be collecting fees, arguing exemptions and managing appeals rather than doing what they are supposed to do, which is making documents available. And so well-resourced applicants may cope, but the ordinary public, media organisations, civil society, community groups, NGOs will miss out. A lot of people who are seeking sensitive material may stop applying if they have to identify themselves. So over time, we believe trust will erode and Australia's commitments to UNCAC and access to information measures that feed into things like the Corruption Perceptions Index will look weaker. So, the bottom line is this bill points to more cost, more delay and more secrecy. We do welcome action on freedom of information, just not this pathway. The constructive course of action is an independent review with public input and some immediate steps that the government can take now to support agencies and users in the short term. So more support for proactive disclosure, proper resourcing for agencies and the OAIC, and a commitment to further review where the public is consulted.
Okay, thank you. So your position would be to reject the bill in its entirety. Is that what I understand from your evidence today?
Yes.
Thank you. What impact do you think there will be with the expansion of the cabinet exemption?
The Section 34, as Bill mentioned, it's already an area where that exemption is overused, and this bill just seeks to broaden that exemption from moving the purpose of cabinet documents from the dominant test to the substantive test. And so this will make it harder for the public to get access to cabinet documents that are needed to expose things that, we've seen so many investigative journalists expose bad governance, from aged care to climate to robo-debt, through access to documents through freedom of information requests, and that would that would limit this.
Okay, thank you. And are you concerned by the fact that under this bill, departments will be able to refuse FOI requests even without even searching for them if it is apparent from the request that it will be covered by an exemption?
Yes, on the face of it, this is not a good policy, but it's not something that we researched in our submission, so I'm happy to take that on notice.
Thank you. Are you aware of any examples of how information under the FOI is currently being used by offshore actors for nefarious purposes, as the attorney said in her second reading speech?
We haven't seen any evidence of foreign actors, making FOI requests. I believe between about 72 to 74% of FOI requests are people seeking their own personal information. In our view, it's unclear that FOI is being used at scale by foreign actors. By itself, FOI is purpose blind, so agencies should assess the content of the request and the potential harm, not necessarily who asks. So the idea that foreign actors or criminal gangs are using FOI to access sensitive material is a bit of a stretch, because FOI cannot compel the disclosure of anything that's inappropriate to publish. And there are exemptions for sensitive material in the Act. There's long-standing exemptions for national security, for defence, for international relations, law enforcement, critical infrastructure, and I think other examples as well of exemptions there. So if the information would cause real harm, it would be unable to be published anyway. But if it can safely be made public, there's no reason to withhold it.
Okay. Thank you, Senator Collins. I'm going to need to rotate the call. It's been 5 minutes. Sorry, there are going to be short blocks of time because
okay. Thank you,
questions. All right, Senator Shoebridge.
Thanks very much, Chair. And I want to thank all the witnesses for their assistance with their submissions and the work you do outside of the inquiry as well. I suppose my first question is to the Australia Institute, and I really want to thank you for your incredibly important report, which I think has been the most comprehensive analysis of what's wrong with the FOI system. But could I first of all go to the question of robo-debt? If this bill is passed and the additional constraints are put on releasing information under FOI, that seems to me to go against all of what we learnt from robo-debt and make robo-debt 2 more likely. Do you have a view on that?
Yes, I think there's a real danger that further restricting the public's ability to access government documents only makes a possible future robo-debt more likely to either occur or to go unscrutinised. We hear from the Robo-Debt Royal Commission the valiant attempts that were made by a range of people, some directly affected, some not, to get to the bottom of how robo-debt had happened, who was responsible, the legality on which it was based. And even under the FOI laws as they currently stand, their efforts were primarily in vain. To further restrict documents I've called cabinet-related, to make them even less accessible, goes against the recommendations of the Robo-Debt Royal Commission, which my interpretation was from their report that even they found themselves stymied by the public interest exception, even outside the FOI system, with the additional powers of a Royal Commission.
Yeah. One of the proposals put forward, I think, by a number of witnesses, not least the Australia Institute, is to actually make for proactive obligations to disclose ministerial diaries and cabinet documents. Now, that'd be a reform I could get behind, but can you explain why that would work and how it would benefit the FOI system?
Yeah, so it's already common practice in New Zealand, where it's a long-standing practice to publish cabinet documents a short interval, about 30 days after they've been introduced to cabinet. One advantage, of course, is that you'd reduce the number of FOI requests seeking that information by making these disclosures standard. But I think the larger benefit is that it means that the information on which government is relying on for its decisions is available to the public, to journalists, to academics, to scrutinise for themselves. And I think public servants who are confident in the quality of the work, who have met their obligations under the Public Service Code, including to give frank advice, would be happy to see their work available to the public to use. I think we saw in estimates with this committee last week that the impression I got was that the Attorney General's Department hadn't really considered the issue of proactive disclosure, even on FOI reforms themselves, which you'd hope, if it ever came to mind, would be on this issue. And had they done so, they could have preempted the 21 FOI requests, which they are still processing to this day.
I'm still waiting for a response to mine. So, but a great illustration of proactive release, avoiding complexity. To either you, Ms. Bredovac, or you, Mr. Brown, I don't know who's best to answer. And again, thank you both for your joint work on the on that extraordinarily important report. One of the issues that keeps popping up is ministerial intervention. Some would say meddling, some would say involvement in FOI decisions. Do you have an understanding about how widespread that is and what reform could possibly look like to remove ministerial intervention, particularly in departmental FOIs?
I guess one thing we've identified is that some of this comes down to culture and the expectations that are set by the government and by senior public servants. To the extent that there's a refusal to put things in writing, I know one submission suggested that the Public Service Commission could take more responsibility for reminding public servants of their obligations there. That would be a good start. Sky, is there anything you'd like to add?
No, I think that's about it, yeah.
Thank you, Senator Shoebridge. You've had your 5-minute block, so I'll need to rotate the call. Senator Cox.
Thank you, Chair. Can I first thank you for appearing today? I'm going to direct my question to the Australian Institute. Do you agree that the FOI system is currently broken?
I think that's a fair categorisation, yes, on the basis of the great time it takes to get things back, the large share of results that are either not granted or not granted in full, expense and so on.
Great. Do you agree that the government agencies should be able to decline repeat or vexatious FOI requests in line with the Hawke Review?
I'm concerned...
given that that's what this legislation actually does.
Well, this legislation does a great deal of things, and the thrust of the changes are to make access to information harder, to impose fees and so on. If the government withdrew the view...
Sorry, Mr Brown, I only have a very, very short amount of time, and the question, I'll just draw you back to that, was, do you agree that government agencies should decline repeat and vexatious FOI requests? That was the question that are in line with the Hawke Review.
If the government wants to conduct a consultation and investigate that issue and propose a new bill, I'll happily consider it as part of that.
So you don't agree that government agencies, if someone makes a vexatious or a repeat FOI request, that under this bill it seeks to amend as per the recommendations of the Hawke Review, you don't agree that they should be able to in fact reject that?
Well, as I understand, there are some provisions for vexatious applications at the moment, and I think there's a great harm in extending the ability of the government to refuse access to documents.
Okay. Do you agree then that there needs to be changes to the extensions of time given for FOI requests in line with the Hawke Review as per the amendments to this, that this legislation actually seeks to change?
I don't agree that there needs to be a change to the extensions of time. 30 days is not unreasonable, and indeed we've experienced with this inquiry itself that when an application is delayed, it deprives the public of the access to information that they can use to make meaningful submissions to this inquiry. We are well beyond the 30-day period and indeed beyond a 20 working day period that would apply under the bill, with applications currently sitting with the Attorney General's Department that would shine a light on the government's decision making on this bill, and we still don't have access to them. Yeah.
In your submission, you said that the FOI workload was at its lowest point than any other time under a previous coalition government. Now, I'd like to table a document to the committee from the OIAIC, which gives us some statistics. So I believe it's being sent out now, that in fact, the requests for 24-25 are at their highest point ever. And in fact, they were up 25%. Do you agree? Well, I'm just going to put it to you that, in fact, that's quite disingenuous, some of your reporting within your submission, to say that the number of requests were, that this government is trying to be secretive, that this is not a real issue that this bill seeks to amend. Like, that's quite disingenuous and absolutely trying to skew some of the data within your submission.
No, I don't agree with that characterisation. Our measure of FOI workload is the number of FOI requests determined. As shown clearly on page 5 of our submission, that's down to 21,000 requests determined in 23-24. The OAIC hasn't published its annual report yet for 24-25, but looking at their database, from what I could tell, it was...
Sorry, just going to interrupt for a second to seek any objections from the committee to table that document. I've had a look at it. I can't see any reason not to table it. Thank you. The document's tabled.
From what I saw of the FOI data, the number of requests determined has increased to 25,000 in 24-25, which again would not be anywhere close to a peak. Now, we do cover the question of other ways of measuring FOI workload in our submission in the appendix. We looked at FOI...
Well aware, Mr Brown, sorry, I'm going to cut you off. I'm well aware that you've done the math in this, but in fact, in your submission, you talk about the figures from 2006 to 2007, comparing those numbers to 22-23. And in fact, they were different frameworks. They were different ways in which those regulatory frameworks were enacted during those two very different periods of time. Do you agree at that? Like, to actually use two separate regulatory frameworks to give two different sets of data basically is comparing apples and oranges. Like, we are now in a state where you've put in a submission that says that there's two different frameworks in which these operate. Like, that's very disingenuous to put that in front of the committee. and say that these are the same things and that we're operating under the same landscape. That is not true.
There were some reforms introduced, and of course, the Faulkner reforms under the former Labor government. But of course, the context of our work in freedom of information is the claims made by the government about their reasoning behind making changes to the FOI system. And they emphasised the changes in technology that happened, including claims that they were inundated by anonymous requests. Many of them, we are sure, are AI bot generated. So the reason for looking at the volume of FOI requests received is because this temporal element is something that was introduced by the government. In fact, I believe it was the Attorney General who went back to 1982 and said technology has changed significantly since the original FOI Act came in 1982. So the association of continuity was one made by the government. The claims that...
Mr Brown, I'm sorry, I'm going to have to move on. I have read your question.
That is all the time we have questions for this witness. Apologies, Senator Cox. We do have our next witnesses in the ready to go. I want to try and keep us on schedule as much as possible today. So I want to say thank you to our witnesses for taking time to give evidence to the committee today. If you've been asked to provide any additional information, would you please forward it to the Secretary by the 24th of October? You'll be sent a copy of the transcript of your evidence, and you'll have an opportunity to correct any errors to transcription errors. And thank you for your time. We will suspend for a brief 1 minute while we welcome our next witnesses.
Thank you.
Thanks very much.
Representatives from the Department of Home Affairs and Services Australia, thank you for taking the time to speak to the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, would you please state your full name and the capacity in which you're here?
Robert Higgins, General Manager, Payment Assurance Program and Appeals, Services Australia.
Jodie Robinson, General Manager, Customer Service Delivery Group, Services Australia.
Brooke Hardigan, Deputy Secretary Legal, Department of Home Affairs.
Peter Anstey, First Assistant Secretary, Counter Foreign Interference, Cyber and Technology, Department of Home Affairs.
Carmen Saunders, Assistant Secretary, Privacy, FOI and Records Management Branch, Home Affairs.
Thank you. Is there an opening statement from anyone?
Not from Home Affairs, Chair, thanks.
Not from Services Australia.
Excellent. I'm sure senators will be very appreciative of being able to get straight into questions, and I will hand the call to Senator Collins.
Thank you, Chair. My question is for Home Affairs. How many FOI requests do you currently have on hand that are known to be generated by AI or by a bot?
Thanks for the question, Senator. Unfortunately, I can't give you a statistic on how many might have been generated by AI or bots. It's just not something that our system collects. I can tell you that we've got about 7,500 FOI requests on hand.
So what evidence do you have then that any FOI requests are created by bots?
Thank you, Senator. We don't necessarily have evidence of it actually occurring to the department. What we're aware of is that the FOI system itself could be vulnerable to requests made by bots or generated by AI.
Okay, but there's actually no evidence to show that any of those 7,500 requests have been made by anything other than a human.
That be fair? I think that's fair, Senator. That's correct.
Okay, thank you. Is it unlawful or otherwise impermissible for a person to use AI to assist in making a legitimate FOI request?
No, it is not to my knowledge, Senator.
No. And you don't have any policy on that at all?
No, Senator.
Okay. Is AI used within your departments in both Services Australia as well?
Senator Robert Higgins, I don't think I can speak to the broad issue of AI used in our agency, other than perhaps at a reasonably generic level to say that we have, trialled Copilot, for instance, and other processes to assist things such as transcription and things of that nature. But I probably couldn't go anywhere beyond that.
Okay, thank you. How many FOI requests are currently on hand that are known to be linked to a hostile foreign power or criminal gang?
Did you want to start?
I'm unaware of that information, Senator, and I couldn't provide any detail on that.
Senator, from the Home Affairs perspective, we have a similar, we're in a similar position. I think in our 2023 submission, what we indicated was that we feel that the FOI framework itself is at risk of, or could be at risk or vulnerable to, foreign interference. And I might ask Mr. Anstey to provide some insight on that.
That's right, Senator, and often these judgments won't come down to individual FOI requests. We know that foreign adversaries are sort of seeking to use legitimate processes such as the FOI process to take seemingly innocuous information and then paint an intelligence picture that may be contrary to the national interest. So you may be familiar with the sort of concept of the mosaic effect. It's difficult to distinguish exactly on an individual request basis how that picture may be drawn.
Okay, thank you. In response to an order for the production of documents, the Attorney-General's Department included talking points that set out the question, and I quote, "What evidence do you have about AI being misused to generate FOI requests?" Close quote. The suggested response is, quote, again, one agency's statistics suggested that of the FOI matters they had on hand, almost 20% of personal matters and 50% of non-personal matters included AI-generated content. Do you know what agency that was?
For Home Affairs, I don't, Senator.
And for Services Australia, no, we don't either.
Okay. Has the department ever released information under FOI in response to a request known or suspected to be linked to a hostile foreign power or criminal gang?
Was that known, Senator? Sorry, did you say has the agency done that in a knowing sense?
So I'll repeat the question. Has the department ever released information under FOI in response to a request known or suspected to be linked to a hostile foreign power or criminal gang? So known, yes. Yeah. Known or suspected.
Yeah. I don't have information on that I could provide at the moment, Senator.
Okay.
Same for Home
Happy
Affairs.
to take that on notice.
Yep.
Okay. Thank you. Is the department aware of any specific instances where it has been alleged that the prospect of receiving an FOI request has resulted in a departmental official not complying with their statutory obligation to provide frank, honest and evidence-based advice to the government free from political influence?
Again, Senator, that's a very broad question. I couldn't speak to that with any specificity.
And Department of Home Affairs?
Would you mind repeating the question again, Senator?
Sure. Is the department aware of any specific instances where it has been alleged that the prospect of receiving an FOI request has resulted in a departmental official not complying with their statutory obligation to provide frank, honest and evidence-based advice to the government free from political influence?
No, I'm not aware of any of those situations, Senator.
Okay, thank you. Is the department aware of any specific instances where the prospect of receiving an FOI request has resulted in a departmental official not complying with their statutory obligation to provide frank, honest and evidence-based advice to the government? I think that's the same, sorry. Does the department censor the advice it provides from government because of FOI?
Senator, not to my knowledge.
Same for Home Affairs, Senator.
Thank you. Former Senator Rex Patrick has raised concerns about the Department of the Treasury spending in excess of $50,000 opposing the release of FOI documents relating to the Stage 3 tax cuts. This was in the matter of Patrick versus Secretary, Department of the Treasury. The documents were released, and do you think that the resource burden or responding to FOI could be reduced if the government were to release this type of document in the first place?
Senator, I can't speak to what, for instance, Treasury did with their documents. All I can say is that we seek to comply with the FOI Act as it exists now, and we will seek to comply with the Act as it exists in the future and release information accordingly.
Same for Home Affairs, Senator.
Same with Home Affairs.
Correct.
Do you think it's reasonable to spend $50,000 opposing the release of documents which ultimately were released?
Senator, I can't speak to the actions of Treasury and what the basis for their thinking was in that regard. I'd have to direct you to the Department of the Treasury.
And same for Home Affairs, Senator.
Okay. Former Senator Patrick sought documents under FOI request for project reports about the Snowy Hydro 2.0 project. Are you aware that the government spent in excess of $500,000 opposing the release of those documents in the ART?
Senator, I'm not aware.
I'm also not aware, Senator.
It seems like an extraordinary amount of money to be opposing the release of these sorts of documents. Would you agree with that?
Senator, again, I'd have to refer you to the relevant department as to their thinking on that issue. I couldn't make a comment.
And same from us.
Okay, the matter is now in the federal court. Are you aware that the government spent $87,000 losing an interlocutory application for protective costs orders, which says the maximum amount of costs which may be recovered is $20,000? Is that an efficient use of resources, do you think? And do you think that the resource burden of responding to FOI could be reduced if the government were to release this type of document in the first place?
Again, Senator, I'm unaware of the documents in question and can't really speak to that specific matter.
We're in the same position, Senator.
Final question, Senator Collins.
Thank you so much, Chair. How much of your department spent in legal fees responding to FOI matters?
Senator, I'd have to take that question on notice. And is that for last financial year, for instance, Senator, just so that we can address it correctly?
At ART or federal court, and the last 3 financial years, please.
Thank you, Senator.
And for Home Affairs, Senator, we'd also have to take that on notice, and we note the request for the last 3 financial years.
Thank you very much, and thank you, Chair.
Thank you, Senator Collins. Senator Lambie.
Thank you very much. I understand that this is for Services Australia. You lost a robo-debt case against a Mr Warren in full court. I'm just wondering what your legal costs for both the Administrative Review Tribunal and the Federal Court were. I'm gathering it's about $500,000. I'm being conservative. Do you know what that cost was?
I'd have to take that on.
Mr Warren's lawyers.
I'd have to take that on notice, Senator. I don't have that detail with me.
Okay. So I'm trying to save the government money here, but after deciding what the law was, the full court has sent that matter back to the Administrative Review Tribunal. Have you handed over all the documents that they have requested so we can get on with the matter?
Again, Senator, I'll have to take that on notice. That's not a matter that I'm directly handling.
Okay, could you get that back to the committee as soon as you can? Over lunch would be lovely. The Royal Commission into Robo-Debt stated, and I quote, "It is likely the scheme would not have run in the same way for the length of time that it did, or at all, if there had been proper stakeholder consultation and transparency in its designs and implementation." The Australian Public Service Commission states in his submission to the inquiry, and I quote, "The current exemptions for deliberative material have made it hard for public servants to do their duty, and the consequences of avoiding written advice about serious risks are evident in the robo-debt." Do you share the Royal Commissioner's view, or the Australian Public Service Commissioner's view? Do you think transparency was the cause of robo-debt?
Senator, I can't speak to the cause of robo-debt directly. I was not working on that program. I think the causes of robo-debt are well examined through the Royal Commission process and the recommendations that have come through that Royal Commission.
Okay, thank you. The people who clear or sign off on ministerial briefs are normally members of the Senior Executive Service. Is that correct? To your knowledge?
That's correct in Services Australia, Senator.
Okay, and the executive and the senior executive service get paid between $200,000 and $1 million annually. Is that correct?
I can't speak to the payment other than saying that would be set out in our annual report, Senator.
Okay, you say that your staff have received harassment. How many times has harassment been referred to the police? Did the police act on it, and has the problems been solved?
Senator, we unfortunately have occasion to refer matters to the police on a regular basis. I don't have the number here, and we have active cases underway and underfoot at the moment. And that's often a combination of behaviour of harassment of our staff directly, but then referral of those matters to police. Following the referral of those matters to police, we at times see people continuing to use the FOI system in order to continue to access information and continue to harass officers. So the types of behaviours that we would see include seeking staff members' identifying details, seeking information to personal records, still continuing to perpetrate harassment through those processes.
So is it a regular thing in the department, or is it just, half a dozen instigators?
In most instances, we find our customers use the FOI process absolutely appropriately, but unfortunately we do have a number of instances where people are using the FOI process to continue to harass staff, and at times we feel that puts us in conflict with our obligations under the work health and safety legislation to maintain a safe workplace.
What does harassment look like in your... What sort of harassment?
I'm probably talking at the more serious end of the scale of harassment, Senator. So the types of examples that we would see include requests for personal information in the context of direct threats to staff and direct threats to their family members. So seeking information to identifying information. We have seen people unfortunately attend staff members' homes. We've seen the provision of abhorrent imagery in the context of an FOI application and our staff being exposed to that. And we've seen the behaviours occur over extended periods of time. So it's rare that it would be a single request. We would see multiple requests over, at times, many years, where a person's particularly fixated or vexatious.
Okay, what sort of training do they go through? The people that are dealing with this?
Yeah, so our staff receive a whole range of training in terms of being able to respond to customers facing vulnerability, but also in attempts to try and minimise the vicarious trauma that at times they're exposed to in managing some of these instances. But our current processes in relation to FOI mean that when we're considering a request, we have to consult with third parties, and that includes the staff members who might be the subject of this ongoing harassment in terms of the release of their information. And so that has the impact of continuing to traumatise staff over extended periods of time as well. So I think even in the face of training, it's insufficient to ameliorate the ongoing impacts on staff.
Okay, thank you. I just have some questions for Home Affairs. You say you process more than 19,000 FOIs per annum. I know you can get extensions for processing them, but I want to know how many FOIs you actually process within default, the 30 days.
Thank you, Senator. I can talk for financial year 24-25. So in that year, we received a total of 20,120 requests. In that year, we finalised 17,297, and our compliance rate, and Ms Saunders will correct me if I'm wrong, was about, is it 37%?
Just have to check for you.
So is that telling me what you've got? That's the percentage of the 30-day default.
Yes, that's the compliance with the statutory time frame. Is that right? Yeah, 37%, Senator, for the financial year.
Oh, okay. So only 37% of you, 37% of the time you're getting that getting that response back within 30 days. Is that correct?
That's correct, Senator. We do our best to process all of the FOI requests, and you can see from the numbers that I gave in terms of how many we finalised. We finalised a lot, but 37% of those were within the statutory time frame.
Okay, and what's the average processing time then across all of the requests?
Yes. There's a difference, Senator, in the sort of processing time for personal requests for personal information and non-personal information. So, again, speaking to August 2025, so for the last financial year, roughly it was about 99 days for all. That's the average across all. For the personal access, it was much higher, so 102, and then, sorry, not much higher, but 102, and for non-personal, 69. So we can process the non-personal requests, it seems, quicker than we can the personal requests, and that's usually because of the scope of personal requests is quite large.
Final question, Senator Lambie.
You say in your submission that some people are being bullied into making a more favourable decision to avoid harassment by a fixated individual. Isn't the decision maker a different person than the case manager, and do the public ever get to discuss issues with the actual decision maker?
I should add a point of clarification, Senator, to our submission as well. We weren't trying to imply that people have made a more favourable decision because they've been bullied, but more to suggest that they have been bullied with the intention of the person bullying them, please change the outcome of their FOI request. I might pass to Ms Saunders for the rest of your question. Senator, repeat it?
Yeah, could you please repeat the second?
Senator?
Oh, yeah. Does the public ever get to discuss the issues with the actual decision maker? Does the decision maker reach out?
So we have case officers responsible for managing each of the FOI cases that we have on hand, and those case managers will often reach out to the applicants to talk about issues relating to scope, to see, whether we're handling the request in the appropriate way, and to make sure that we're trying to get them the information that they're asking for. In terms of having a conversation with the decision maker makes a decision in accordance with the FOI Act. They don't tend to liaise directly with the client.
Thank you very much. Thanks, Senator Lambie.
Thank
Senator
you.
Shivridge.
Thanks, Chair. Thanks, everyone, for your attendance and the help with your submissions. Just quickly to Services Australia, that summary of incidents that you gave of threats, of people following someone to someone's home, of harassment, that's all currently illegal, either under state criminal law or under federal telecommunications law. I'm assuming that you have processes in place to protect your staff from conduct that's illegal. How many AFP referrals have you had related to this, and how many successful prosecutions have you had in relation to this illegal conduct?
So I don't have that information on hand, and we can take that on notice. And we do routinely engage with the police and refer matters to the police in order to support our staff safety. But at the same time, where we have an FOI application, we have to still consider that FOI application, engage with the applicants, seek the documents, and engage with third parties to which information might be related to. So we have to do that simultaneously.
You see, if I was Services Australia and there was some pattern of conduct like this that you put forward as a reason to fundamentally change the Freedom of Information Act, I would have come to this committee knowing how many police referrals there'd been, how many successful prosecutions there'd been, and some clear case studies of where that behaviour had cut across FOI rather than sort of generic statements. Makes me concerned that if this is a credible issue in Services Australia, you don't have the protective measures in for your staff. Should I have that concern?
I don't believe you should have the concern that we don't seek to protect our staff, because we take very proactive action in order to support our staff, and we do that in a range of different ways, including engaging with law enforcement and diverting staff to alternative roles where we need to do that in order to protect them. So that's always of our paramount concern.
Let's get some detail on notice rather than these broad generic statements we've got. So I give you that
Point
opportunity.
of order, Chair. I think the official has already taken this point on notice for Senator Shoebridge. I think making statements to lift his platform on social media is not appropriate to badger the witness. The official has taken it on notice, and I think it's inappropriate for Senator Shoebridge to pursue that line of questioning and to make those sorts of statements towards the official.
Senator Cox. Thank you, Senator Cox.
Well, Chair, you're going to make a ruling on that because there was no merit in it, and if it's going to keep happening in a hearing that we have only very short times with witnesses, it's going to be quite destructive to an online meeting.
Proceed with your question, Senator Shoebridge.
Thank you. So just to be clear, you will be providing that detail on notice.
I've taken the question on notice, yes.
All right, thank you. I see that one of the concerns that Home Affairs has put forward is this continued line that we get from government agencies in the context of this, that there are some concerns that AI bots are making applications. And am I correct that you don't have any numbers? You can't point to any individual example, but is there a sort of vibe here, an AI bot vibe that we should be aware of?
Thank you, Senator. You're correct to say that we don't have any numbers of our system being approached by bots. But I think in our submission, the point we were trying to make is that that is a risk that we could be approached by bots. And at the moment, we wouldn't necessarily know unless we can see a lot of repetition on a particular thing.
You know, I don't think it would be revolutionary to put in place a capture provision on a department's website, which seems to be able to be put in place in countless other form-based websites and countless other places. Have you considered doing that off-the-shelf technology to try and protect the department from bots?
I think at the moment, Senator, we actually have a procurement process underway for a new FOI case management system for the department. I can't speak to that specifics. I'll see if Ms Saunders can add anything.
The other point, just to add, Senator, is that we have multiple avenues through which people can submit an FOI request. So by mail, email, or via an online form. If the department were able to direct all applicants to use an online form, that would be a way that we could then employ some technology to do those checks.
I don't think AI bots are going to be putting it in the snail mail, though, are they? That's an unlikely problem, unless you're aware of some, mailing AI bots that I'm not aware of.
That's correct, Senator. We wouldn't expect a bot to be putting it through the snail mail, but the point I was making was that if we were able to direct all applicants to put their submission through the online form, we could then use technology to assist us in order to identify whether or not a bot was submitting those requests.
Well, even if you had concerns, having some process to go through a capture process, which would be a far different set of reform packages than what we've got with this bill, isn't it?
We take your point, Senator.
It would be very different to what this bill is proposing, a modest change like that.
I'll reserve my opinion. I'm not going to offer an opinion on that. Thanks, Senator.
You are aware, though, aren't you, that AI bots have no right to get access to information, that if you can identify a request that's come from an AI bot, you simply don't have to process it, because the Freedom of Information Act only gives a right to information to people, to persons. AI bots have no such right. You're aware of that, aren't you?
I think the point we were trying to make, Senator, is that the validity request at the moment is quite simple. It doesn't require too much information from the requester. So the advantage of the bill in requiring identity, and as Ms Saunders has said, if we can institute some more requirements in the submission of a request, this will help us in identifying where things have come from.
I'm just checking. I'm assuming Home Affairs has provided some input into this bill. You're one of the agencies that provided input about your, concerns about foreign bots, your concerns about foreign agents. I'm assuming you've had some input into this bill, is that right?
We have been consulted on the bill's development, yes.
And in the course of doing that, did you remind all the agencies and give them some clear, unambiguous advice that there is no obligation to process any Freedom of Information application that comes from an AI bot, because they're not a person and they don't have a right to access to information under Section 11 of the Act? Have you given that unambiguous and clear advice to other government agencies?
Senator, I haven't, and the advice and support that we've sort of given AGD in the development of the bill has been wide-ranging. Ms Saunders...
So let me get this right. There's all this agitation, all this heat and light from the government, including coming from Home Affairs about fears of AI bots and the impacts that it'll have on FOI. And no, Home Affairs hasn't at least ever provided advice that actually you don't need to process something from an AI bot. That information hasn't come from Home Affairs. Is that right?
As I said, Senator, I only can speak for myself. We've given a whole bunch of case information to AGD, so perhaps I'll take your question on notice.
Have you got it from any other department? Has Home Affairs got it from the Attorney General's department, which has also been running the AI bots, or from Minister Butler's department, who's been running the AI bots argument? Has any part of government said you don't have to process FOIs that come from AI bots that you're aware of?
Not explicitly, but everybody that is currently processing FOIs under the FOI Act, we are aware that you do not have to provide information if it's not to a human.
Or perhaps you can provide me with where that's put in a policy document, where that's been put in a communication, or where that's been said in any kind of official way in the last 12 months, given how much we've heard from the government about concerns about AI bots. Could you take that on notice?
Yes, Senator, we can take that on notice to see whether we've made that explicit in our information that we provided to the Attorney General's Department. Or
I'd be happy if it was implied or rumoured or referred to in an oblique way.
Senator, I think it's definitely been implied. Ms Saunders has said that people are aware of that, so I don't know that it's been discussed explicitly.
Thank you, Senator Shoebridge, for that clarifying the question on notice request there. Now I need to rotate the call. Senator Cox.
Thank you very much, Chair. Can I first go to questions for Home Affairs? Within your submission, it notes that the legislation will increase protections for people fleeing domestic violence or in child custody arrangements. Can you step us through what some of the department's concerns are in relation to those risks possible?
Yes, thanks, Senator. I'll start, and Ms Saunders might want to add. As you'd know, the Department of Home Affairs has, a vast holdings of personal information relating to people, whether it be visa applicants or other, and that information is comprehensive. We are aware that relationships might break down. An ex-partner might seek to put in an FOI request to get information about the former partner or children, we need to put in place processes at the moment to determine that, and then to have that apply when we're looking at the material that's within scope of the FOI request. With the changes in the bill requesting identification, that's one way that we can sort of mitigate that, because at the outset we will have that established before we go and collect a whole bunch of information about the particular request. But Ms Saunders, you might want to add something to that.
No, you're very correct. I think one of the issues that we're looking to mitigate here is the fact that, given the sensitive information holdings that the department does have, when we do receive a request, we must, action that request appropriately. So go and collect all of the documents, have a person look at those documents. So that could have a whole lot of personal information in it that, the general public might not be aware that that's exactly what we have to do. We have to go out and collate all of the documents, assess them, determine whether there's any harms of release, look at whether there's third-party information in there, and we do that whilst we're asking questions about identity. The changes proposed in the bill would mean that identity verification is a validity requirement. So that would mean you'd have to prove your identity before we go and search through everybody's personal information to get to satisfy that request. So on one hand, it's an administrative ease, because we wouldn't need to process and go through that whole process of trying to get all of the information together, but also it's a protection for people's privacy, because it means we're not accessing it, we're not looking at it, we're not collating it, and then we're not accidentally, releasing it to the incorrect person. So it's got multiple protections, and really where we're positioned from a Home Affairs perspective is that we want to ensure that clients get access to their information. We want to make sure that we're maintaining people's privacy at the same time.
Thank you. And sort of that goes it's a good segue to my next question, because there are potential risks arising that this bill seeks to mitigate in relation to anonymous FOI requests relating to identity fraud. I think that your submission also references. Can you tell us a little bit more about that?
Yes, Senator, because at the moment people don't need to establish their identity when they make a request, and given the holdings that we have in the department about people's personal details, ranging from date of birth, location, qualifications, children's names, citizenship, marriage certificates, etc., it is understood that could be attractive to people who want to use that information for identity fraud. So we're conscious of that, and I think that requiring identity at the outset, as Ms Saunders has said, gives us that information before we commence on the collation of all the information pertaining to the request.
Yeah, thank you very much for that. Would the department support an approach where the Privacy Act, rather than the FOI Act, was actually the primary means for people to obtain access to their personal information? I know that this has been a contentious point of this bill.
In short, we would, Senator. Yes. I can't speak for Services Australia about that.
Thank you. I might direct my questions to Services Australia. Do you consider that the measures to require that the request be made from a person will help the agency to focus on responding to genuine requests for information? If so, can you outline why?
Yes, we do, Senator, for very similar reasons that were just explained by Home Affairs. If we're aware that it's a genuine request at the outset, that it means that we can focus our time and effort on retrieving those documents, assessing those documents and releasing them as appropriate to the genuine request. In instances where the person doesn't have a valid reason for requesting the information, we divert a lot of effort to undertaking those activities in situations where the applicant is actually not entitled to the information, but currently we're still required to go through those processes. So yes, we think it will lead to efficiencies in how we're able to administer the FOI scheme and ultimately get people quicker access to their personal information that they have an entitlement to.
So in fact, contrary to what was just relayed in the previous questioning, that regardless of, under the current legislation, which this bill seeks to amend, there still needs to be some handling in relation to fact-finding and the validity of these requests, and a whole lot of work that I think has been in the first tranche of witnesses that came in on the panel that talked about how much time that takes. There's an enormous amount of work that goes into that. Am I correct?
That's right. We have to accept the FOI request and consider that request and consider whether there's any exemptions to releasing the information, even if on the face of it it would appear that the applicant wouldn't have an entitlement to the information. We still have to go through the process of retrieving the documents from our sort of vast number of systems, reviewing all of those documents, making a decision in relation to exemptions, and then writing a decision statement to provide to the applicant. In circumstances where, in some instances, it would appear from the outset that the applicant wouldn't have an entitlement to the information. For example, if someone is seeking access to somebody else's personal information.
So, just so I'm very, very clear, I'm sorry, I can't see your nameplate from where I am. The camera hasn't got me far enough down. So I can't address you by name, but essentially like the complexity and the size and volume of these requests has increased over the past 3 financial years. And that we are talking about government efficiency. We are talking about the time that it takes our public servants to be able to ensure that the handling of these, whether they're requests that for FOI that become not valid, that are withdrawn or for whatever reason, that this is about ensuring that we achieve better outcomes and making sure that we are increasing the efficiency of government departments in relation to FOI. Can you just talk us through what Services Australia in particular has seen in the recent years in relation to the complexity of some of those requests?
So if I speak in general terms, Senator, Services Australia, similar to Home Affairs, holds vast information in relation to our customers. We administer Medicare, child support and social security. So we hold information in relation to people from birth right through their major life events and, unfortunately through to their passing as well. Our information keeping systems, information record systems are vast as well, so often retrieval has to occur over a significant number of systems, and in most instances we release information to individuals on an administrative basis. So people will attend our service centres, they'll go in, they'll request some information and we're able to print it and provide it to them at that point of time, and we release much more information under those sort of straightforward administrative release processes. So as a result of that, the FOI matters that we have on hand are typically the sort of larger requests, so larger in scope, typically seeking vast information over extended periods of time, and more complex because they seek personal information not only in relation to the individual but often in relation to third parties, which might be extended family members, it might be separated family members, it might be sort of step families, a whole range of permutations of that. So as a general rule, the FOI requests and caseload that the staff are dealing with is more complex.
Thank you, and that's actually my last question, but I just wanted to say that this is important because the officers that are attending to some of these requests, I think alluded to by Senator Lambie in her questioning, there is harassment, there is abuse, and there are instances when these situations can get out of hand. So thank you for your evidence today. Thank you, Chair.
Thank you, Senator Cox, and thank you to the officials for taking time to give evidence to the committee today. If you've been asked to provide any additional information, which I know that you have from senators here today, would you forward it to the Secretary, please, by the 24th of October? You'll be sent a copy of the transcript of your evidence and you'll have an opportunity to request corrections to any transcription errors. Thank you very much. We'll take a very short 1-minute suspension while we welcome our next witnesses to the table. From the Australian Council of Social Services, the Australian Conservation Foundation, Miss Emily Mitchell in her private capacity. Thank you all for taking the time to speak to the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is also available from the Secretariat. Also, for the hand-tied record, would you please state your full name and the capacity in which you appear today? We'll start in the room first and then we'll go to those online. I can't hear. Do you want to try the...
Yeah.
That microphone's not working. Little musical chairs. All right, well, maybe we'll go to the people online while we're sorting out the microphones in the room. Ms. Crowe? You're on mute. Yeah. No, there you are. No, you're good now.
Yeah. Good afternoon. Charmaine Crowe, Program Director, Social Security at the Australian Council of Social Service.
Thank you very much.
Good afternoon, Matthew Clare, Solicitor for the Australian Conservation Foundation.
Thank you, Mr. Clare. And we'll go back to the room and see how we're going with microphones.
Emily Mitchell, appearing in private capacity. Thank you.
Excellent. Thank you, Ms. Mitchell. Would any of you like to make a brief opening statement?
I have an opening statement available.
Excellent. Thank you, Ms. Mitchell.
Thank you, Committee, for the invitation to appear before you today. I appear today in a personal capacity as I've made many FOI applications over a span of 14 years at a range of organisations. At present, I'm employed as the Pacific Mining Program Director at Jubilee Australia Research Centre, and so also draw upon my experiences there where I work on increasing corporate accountability. FOI has featured extensively in my research. It is unique and it is the best tool that I have as an investigative researcher and must be protected at all costs. I may seek to apply under FOI after having a conversation with someone about a systemic issue that they are witnessing, finding a potential weak point in a corporate environmental monitoring report, developing a hunch based on other research, or reading that a key document exists which sheds more light on a systemic issue. FOI provides an avenue to explore and to find an evidence base for my hunches or curiosity. Most of the time I have not been wrong, however I needed the evidence base to confirm my suspicions. An FOI investigation provides an avenue to investigate systemic issues, identify patterns and establish an evidence base. I publish the information found alongside comprehensive research, make recommendations and release the report to the media. FOI enables this across a wide scope of research areas. When I look at the media today, I see scope for more FOI investigations than is currently occurring. I believe that civil society in Australia could be using FOI much more frequently than it currently is and with powerful impact. I believe there needs to be more FOI applications, not less. I am firmly opposed to any cap on processing time. A deep investigation is sometimes required to truly examine or explore an issue and to truly develop an evidence base. For example, 6 hours processing time may get you a few letters and maybe a report. If any redactions are required or consultations, I believe this may add to the processing time. My FOIs regarding the Montara oil disaster, to Comcare regarding immigration detention, and regarding Indonesian teenagers held in adult prisons would have all far exceeded 40 hours in processing time. If the changes were in place, these investigations may never have occurred. FOI plays a key role in encouraging accountability and learning from mistakes. If access to FOI is limited via processing time caps or broader exemptions, this impedes the ability of the Australian public to even be aware that mistakes or oversights are occurring. This would not just be failures of the Australian government and its agencies, but of the actors that they seek to regulate. If the Australian public are not even aware of mistakes when they are made, how can we learn from them as a nation and make changes for the future? The proposed amendments also give a very vague and sweeping exemption from matters that are under deliberation and where timely advice is being given by an agency. I believe that under these amendments, a broad refusal could be given in situations where there is a national emergency response, such as an oil spill disaster, with no opportunity for civil society to develop an evidence base to seek an urgent change in response direction. There are areas I wish I could FOI and face extensive limitation. Export Finance Australia is exempt. I recently got knocked back from the ATO when I sought access to tax deductions from a corporation, as it is protected information. There will be new information required to be disclosed soon due to the Making Multinationals Pay Their Fair Share legislation. However, it remains to be seen as to whether I will be able to dig any further or may be blocked, as it may count as protected information. A key strength of FOI as a research tool is its unpredictability. You never know what you may find or where it may lead you. It can also have broader significance for those seeking justice. I could not have foreseen that information I sought under FOI for overflight maps monitoring the Montara oil disaster would later be tabled as key evidence in a class action representing more than 15,000 seaweed farmers in the Federal Court of Australia, which settled for more than $190 million. Any catch cry of national security as a rationale to wind back democratic freedom should be always viewed with extreme caution. Allegations of offshore bot applications is surely technical rather than legislative. Submitting applications using capture verification rather than by direct email may assist. We need more applications submitted in public interest, and they should always be free. There should never be a fee incurred for applications made to assist Australians in increased public participation and discussion. Section 3 of the FOI Act acknowledges that information held by the government is to be managed for public purposes and is a national resource. I seek that this committee preserve in full the right of the Australian public to access our national resource. FOI is an important bedrock of how civil society can take the initiative to hold government agencies and regulators and the actors whom they regulate to account. It is powerful, it is important, and our rights of access must not be wound back.
Thank you very much, Ms Mitchell. I understand that the Australian Conservation Foundation have got an opening statement as well. Mr Clare?
Thank you, Senator. I think my colleague Annika Shu is there. I might let her use our statement.
Hi, Senator. Thank you for having us, and thank you for your patience as I ran up the stairs to get here. And apologies in advance.
Ms Shu, would you just state your full name and the capacity in which you appear before the committee?
Yeah, my name's Annika Shu. I'm the lead environmental investigator at the Australian Conservation Foundation, and Matt Clare is my colleague here, solicitor at ACF.
Excellent. Thank you very much. Would you like to make the opening statement?
I'd love to, please. So, first of all, ACF, we're the national environmental organisation in Australia. We represent over 500,000 Australians who care about nature. FOI is vital to our work, both in our advocacy and in our communication with our supporters. So, when they go to the ballot box, they need to know how the government's performing on the policy issues they care about. And when we advocate on their behalf and on behalf of nature, we really need to know how decisions are made. We need to know where the sticking points are so that our advocacy is efficient, smart, not based on misinformation. I'm sure it's been said a few times today, but FOI is the bedrock of our representative democracy. It's extremely important that the public is aware of how the government is doing what it does in their names, using their taxpayers' money. FOIs in the past have enabled us to find things like a coal baron lobbying the Environment Department to receive carbon credits for his coal-fired power station. A foreign uranium company successfully lobbying for a rushed approval of its mine with watered-down environmental conditions, which could lead to the extinction of 12 individual species. There are serious flaws in the FOI regime. We were here only 2 years ago explaining those flaws to this committee, explaining that we've waited up to 2 election cycles to see documents which were vital to election issues such as climate change. It's disappointing to see this bill. In my view, the bill would pour petrol on that fire. It flies in the face of the findings of the 2023 inquiry and countless other investigations into the FOI regime. It will cost applicants and the government more time and money. It will generate more reviews. We want an evidence-based bill, not one based on bare assertions. We want a fulsome public inquiry that will tackle these issues head-on. While there is a culture of secrecy in the Commonwealth Government, there will be FOIs, there will be more FOIs. While the community feels that the government is holding back, it doesn't have full information, it feels that it can't trust the government, it will press the only button it has, which is FOI, and when the community is disappointed with that result, it will review those decisions. It's going to create so much work. I'll pass now to Matt to talk about the more detailed, intelligent points of our opening statement. Thank you.
Thanks, Annika, and thanks, committee, for having us. I act for ACF primarily as a review solicitor in the FOI space. I just want to speak a little bit about the way that culture of secrecy really shows its face when you're not only seeking access to documents, but seeking internal and then external review.
Sorry, Mr. Clare, I want to, if I can, encourage you to be brief in your addition to the opening statements, because I'm not sure if ACOS has also got an opening statement and a bunch of senators who want to ask questions. So if I can encourage you to be make a short contribution so we can get to questions, please. Sorry, I don't mean to interrupt.
No problem. Thank you, Senator. I'll try to be less than 2 minutes. I'll just briefly mention, and perhaps the committee can ask questions about this, but ACF's experience has been very consistent with statistics that the Information Commissioner has provided and that the Australia Institute has very usefully analysed around the increase in access the further away reviews get from the original decision maker, the further away they get from the line area or from the agency or minister that's tasked with making a primary decision. And so I think the key point that we want to emphasise there is that there really is that culture of secrecy. We see it in practice, and we see that the further away from self-interest, the more clear-eyed reviewers can be and the more access there is. The other point I want to emphasise is that the culture of secrecy is expensive. It seems that the key mischief that this bill is trying to address is administrative burden and time and cost in the FOI system. But in ACF's view, that would be best achieved by granting more access earlier rather than increasing the extent of time over which applications can be processed and increasing the extent of exemption contentions that can be made over documents. That is inevitably going to increase reviews, and that is inevitably going to increase cost. We don't know exactly how much agencies and ministers spend on internal and external reviews of decisions, but we know it's substantial. Like the committee's heard some information about reviews commenced by former Senator Rex Patrick and the incredible costs that are involved in that. That's also consistent with ACF's experience. The amendments in this bill are just going to make that worse. I want to particularly point out the amendments to the public interest test affected by the amendment to the objectives of the Act and to the public interest test in Section 11B. Those are just going to entrench existing attitudes of secrecy and prioritising the secrecy of government operations and of industry stakeholders. And the proposed new power to refuse requests without identifying documents, that's inviting abuse within that culture of secrecy. You'll set up a chain of decisions and reviews where no one ever looks at the documents. They just assume that because these documents are government information, they must be secret. That's entirely antithetical to the operation of the Act as it currently stands, and entirely antithetical to accountability of government in a democratic system. Thank you.
Thank you very much for that. Would you like to make an opening statement, Ms. Crowe?
Look, Chair, in the interest of time, I'm happy to send that through to the committee if that would be amenable.
Grateful. Thank
problem.
you very much.
Okay.
We will proceed to questions and I'll go to Senator Collins.
Thank you so much. And I want to thank all the witnesses today for giving their evidence, and particularly as a former researcher myself and having come up against the barriers of getting information from government, particularly even working at the Lowy Institute, it was very difficult to do. And I want to acknowledge the work of the Jubilee as well and all the work that they do for economic justice in the Pacific region. I came across it a lot in my work at the Lowy Institute as well. So thank you so much. And don't give up on trying to get that information. I just wanted to ask, and this is a question for all the panel, so feel free to all answer this question, but do you consider the bill should be passed in its current form?
No.
No.
No, Senator.
No, Senator.
And thank you. And would you recommend that the Senate rejects it outright?
Yes.
Yes, Senator.
Yes, Senator.
Yes, Senator.
Thank you so much. And can I just have a quick summation from each of you, if you choose, just very quick, why you think this should be rejected? What's the biggest problem with it?
I might pass to Matt Clare, my colleague.
And very quickly as well, just, concise answers, please.
Very quickly, there's more detail in ACF's written submission, but the key point is that this bill seeks to make the FOI system easier and cheaper for users and for government, but it doesn't achieve that in practice. It will just make things more expensive, more time-consuming, and more complex. Addressing the culture of secrecy and increasing access is the best way to achieve the outcomes this bill seeks to achieve.
Thank you. Anybody else want to add?
Senator Charmaine from ACOS here. Look, in our view, this rather than increase transparency in government and make it easier for people to use the freedom of information system, this is just simply going to make it more difficult. It's going to stop the release of more documents and ultimately reduce transparency in government, and that's fundamentally why we oppose this bill in its current form.
Thank you. So the bill appears to have two main functions, and the first is limiting the inflow of applications by inserting a cost barrier and removing anonymity, and limiting the release of information by expanding exemptions. Why do you think the government is doing this? And this is a question for all the panel, whoever wants to jump in.
In terms of the applications that are coming in, government has been saying that the majority of FOI applications are for people seeking personal information. However, the bill does not propose that those applications would incur a fee. So to me, it appears a bit inconsistent, the rationale for why a fee should be introduced, because essentially it would be organisations like ours who are seeking to use FOI that would be charged the fee when we are seeking information in the public interest. So I don't think the rationale there has really been made out clearly. In terms of the removing anonymity, I was able to hear a little bit of the evidence given by Services Australia. It appears that there are agencies that are struggling with this anonymity issue. However, we would be seeking evidence from a very broad range of Commonwealth agencies where we're not seeking personal information, and sometimes whistleblowers do need to preserve their anonymity. I'll defer to my colleagues on the other points.
Anybody else want to add anything?
Thanks, Heather. I'll add something to that. In terms of the procedural issues around fees and anonymity and vexatious proceedings and so on, I think ACF can understand the objective, but our key concern is that that objective doesn't seem to be achieved in the whole of this Act. They're introducing a number of different procedures that will just increase burdens and time and cost, and there will be better ways to achieve those outcomes, streamlining FOI procedures, that we think would be shown up most effectively in a comprehensive public review rather than in the form of sudden amendments and a Senate committee inquiry. In terms of exemptions, we can only guess that the government finds it uncomfortable to disclose information where it would prefer that be secret, either for its own purposes or for industry stakeholders. That seems to be the objective behind the amendment to the objects and to the public interest test, as well as cabinet exemption. And we would just emphasise that, that's really entrenching the culture of secrecy that will just increase cost and time and decrease access to critical documents that ACF uses to protect nature and people.
Can you just put that in relation to the public service value of being obligated to provide frank and honest information and advice? Do you feel like there's going to be an impact on public servants who have that obligation?
Thanks for the question, Senator. I think that it does. The way that the language that introduces the consideration of frank and timely advice or prejudice to the operations of government sits in the Act, I think sits very uncomfortably with the APS values. Those will continue to exist and, in our view, should take priority. It should be the case that all public servants are acting in a way that gives frank and fearless advice at all times. I think we've heard evidence during Senate estimates and during these proceedings that is the attitude that government agencies strive to achieve. So we're not sure why you would need to amend the Act to embed this. That'll just increase complexity.
Thank you, Mr. Clare. Senator Shoebridge.
Oh, thanks, Chair, and thanks everyone for your engagement. I suppose my first question is to ACOS, and you were so close in following that Royal Commission into Robodebt, and I think Commissioner Holmes in that said that had the executive minute and cabinet papers on Robodebt been available for public scrutiny, it would have become apparent the cabinet was basically told nothing, and yet this proposal from the government suggests that we should get even less information about cabinet decisions and what informs a cabinet decision. How does that play with what you found out through following Robodebt?
Thanks, Senator. Look, that's one of the key reasons we made a submission to this inquiry, was because in our view, had documents that were requested under Freedom of Information back in early 2017 been released at the time, shortly thereafter, it may well have happened that Robodebt was stopped much sooner than what it was, and we would have avoided all of the harm that occurred thereafter. It is why it's our firm view that we need to be expanding access to documents made available under Freedom of Information, and it's why we supported Commissioner Holmes's 57th recommendation in the Robodebt Royal Commission that indeed the cabinet exemption or Section 34 of the Act be removed, because we think that those documents that were eventually released, I've looked at them, that would have been so powerful and valuable to have had at the time, and instead it took 7.5 years under the current Act for them to be released after many reviews and the government fighting it at each and every turn. So that's why we're somewhat flabbergasted that the government is moving to tighten access to not only cabinet documents but others, rather than expand access and boost transparency.
And it's not even just through that specific set of reforms making it harder to get cabinet information. This bill also proposes a whole lot of additional restrictions, almost like blanket reasons to refuse any information about a deliberative process, as a policy is being developed and proposals are being put forward. But again, Robodebt is proof positive that if that sort of information had been properly available, well, it might have stopped this, that appalling project before it even started and before lives were lost. What's your view about the changes on deliberative documents and processes?
We're strongly opposed to them. I mean, look, public servants, as we know, have within their code of conduct to provide the best advice possible, to provide frank and fearless advice. And we do not think that the possibility of publication of that advice should affect that. If anything, that should encourage public servants to provide the best advice possible and to be frank and fearless in that advice. That would support public servants to do that in our view, whereas this bill seeks to do.
It looks like we've lost Miss Crowe for a second there.
I'm very suspicious of what the government's done there.
Come on now.
Yeah, and I might ask some questions to the ACF and the other witnesses. One of the concerns that's raised by the ACF is the changes and the compromising of the public interest test, which is kind of core and fundamental to the FOI Act. Do you want to just briefly set out your concerns there?
Thanks, Senator. The concerns that we have start with the amendment to the objects of the Act. You may know that the objects of the Act are then worked back through the public interest test for public interest conditional exemptions. So they're pretty important. And at the moment, they recognise that government information is a public resource to be managed in the public interest, and that transparency and scrutiny of government activities is in the public interest per se. So when a government decision maker is looking at an FOI decision or access request, they need to determine whether or not there are countervailing public interest matters that act against that underlying public interest in access. The amendment to the object will make the Act much more equivocal. It'll recognise government secrecy and private interests as on an equivalent level to that fundamental interest in access and scrutiny. And we think that'll very significantly water down public interest test as it's applied not only at the level of primary decisions, but more concerningly at a later date, where we found that information becomes more accessible on review. Later decision makers may be bound to look at the interests of industry stakeholders, for example, as an equivalent interest to accountability, transparency and scrutiny. The other part of it is the amendments to Section 11B in relation to deliberative matter. We've talked a little bit about frank and timely advice and the way that that sits very uncomfortably, if not contradicts, the existing APS values and code of conduct. But they also seek to embed in that test prejudice to the operations of government. And the explanatory memorandum has a very concerning explanation about what they think prejudice to the operations of government would be. They say that it would include distracting government from its operations. And it's really just emphasising, I think, that there's this culture of secrecy and this culture of FOI not being considered core business. It's set off to one side, and if it's inconvenient for a decision maker to deal with it, then they'll be entitled not to deal with it under this bill.
Thank you, Mr. Clerk. Thank you.
Can I ask for one question on notice, Chair? Just to ACOS.
You can put one question on notice and make it very brief, please, because I've got to rotate the call to Senator Lambie.
I understand. One of the issues from RoboDebt was public servants who knew about what was happening had the ability to put in anonymous FOI requests. Could I ask you to reflect on that, and maybe either of the other witnesses too, about why it's important to maintain anonymity, particularly for internal whistleblowers? And if you could answer on notice.
Can do. Thanks, Senator.
Thank you, Ms. Crowe. Senator Lambie.
Thank you. I was just wondering, sorry. Yeah, I think I only have one question for you guys, so, and you can all answer it if you like. You've all had your own successes in exposing the government conducting by using the FOI system. Do you think how can it be done better under the new secrecy provisions in the bill? Is there anything there that makes it better?
Not really.
Does someone want to?
Yeah, Senator, it's difficult to answer that question because I think we're all grasping for anything that is salvageable in the bill, to be honest.
I was wondering why there was crickets. I'm thinking, Jesus, I know how bad it is. I thought you guys, between the three of you, pick up one thing at least.
Yeah, I mean, mostly there are issues. Mostly it reduces access to information. And we've all been able to access information eventually because we are professionals. We all, in our own ways, have experience with the law, with the public service. I was a public servant for nearly 8 years and worked on the other side of FOI requests, which gives me a great advantage. And even so, it would take me, on average, I think, 2 years to access information, and that's partial information, very rarely entirely what I'm looking for. I think we did make a few recommendations for tweaks that could sort of be made to the bill, which would kind of be like rearranging the deck chairs on the Titanic, but we can go into it if you'd like. Shoebridge is shaking his head, so maybe not. We really would recommend a fulsome inquiry. I think it's important that anything that's done on something this important is evidence-based, and appreciate that this committee is seeking evidence from folks like us now. It's really important. But yeah, a fulsome inquiry is absolutely necessary, and we think probably a difference in posture from the government would go a long way, and that's a cultural thing. It doesn't require Parliament. That's about executive government doing some navel gazing and thinking about who it serves and what the purpose of public information is, and rethinking the right to information and thinking more about proactive disclosure, avoiding, the administrative burden of the FOI Act altogether. Basically, no. I don't know if anyone else has anything to add, but I don't feel that there's enough in the bill that's salvageable to increase transparency for stakeholders like us.
Thank you.
If something from ACOS here, if I can just jump in and say, we would love to see it not be a requirement for individuals who are accessing their personal information, particularly through Services Australia, to have to lodge a Freedom of Information request to do so. As Services Australia has said, that the vast majority of their applications are for personal information. It just seems crazy to us that they're dealing with all of these FOI requests for people's own information that they should have access to without lodging or going through this administrative burden. So And that would, of course, release Services Australia up in terms of their FOI team and focus on other requests. Thanks.
Thank you. And
can I just add to... sorry, you go, Emily.
Oh, thank you. I just wanted to say that I don't really see anything in the bill that is improving the situation for civil society to be able to access information. If anything, it's sort of just chopping the legs out of the FOI regime as it is. The processing cap in particular, I could talk at great length about that, but essentially it's only going to allow civil society very shallow applications, which would be making it not as effective, the information that we would receive. And even with the exemptions in place, we may not receive it at all, or we may have to go through review processes. So it's just making the whole process a lot more difficult for everybody under these proposed amendments.
Okay, yeah, I think they chopped off the whole body, not just the legs. I think there's just little hairs, they're just bubbling above the surface. Do you have anything to say? Anyone else?
Thanks. Yes, I was just going to add to that, Senator, that I agree there's nothing in the Act that improves access for organisations like ACF. There are minor sort of unobjectionable procedural reforms that I won't bore you with, but the real substance of the Act just makes it more difficult. ACF's submission primarily sought that the bill be refused and that the FOI Act be referred to an independent public review. We did make some other tweaking submissions, primarily to make the point that the government seems to have taken a big mallet to this problem and not have considered a number of the issues that arise when you actually work through these amendments, and that there are much less burdensome ways to approach this. But we don't think that those recommendations are the be-all and end-all. We think that it should be submitted to a public review to really work this problem through, given the significance of this for the public.
Thank you very much. I have no further questions. Thanks, Chair.
Thank you, Senator Lambie, and I will remind witnesses to refer to senators using their correct titles. Senator Cox.
Thank you very much, Chair. Can I first go to ACOS? In your submission, you support the repealing of the Cabinet exemption in its entirety. I just want to test with you that do you accept that the Cabinet exemption is designed to protect the confidentiality of Cabinet processes that is in fact consistent with our Westminster system of collective ministerial responsibility?
Yes, thanks, Senator. Yes, look, we do support the Royal Commission's recommendation that it made with respect to Section 34. It called for the removal of that section, but it also called for the amendment of the Cabinet Handbook to clarify that, where release of documents go against the public interest and some other qualifications, then they would be exempt from FOI. But really that recommendation, as we understand it, is about allowing access to Cabinet documents, where a decision's been made and it's, there's nothing against the public interest to keep that confidentiality. The Royal Commission referred to other jurisdictions where Cabinet documents are released, in a very short time frame after Cabinet decisions have been made, referring to the Queensland Government's example as well as that of New Zealand. So there are examples that Australia could follow in this respect. And look, more broadly, we do support an expansion of access to documents, including Cabinet documents, rather than a curtailing of those documents, which is what this bill would do.
So, I'm still trying to figure out, Ms Crowe, what benefit would that be to give in detail in relation to a Cabinet document? Wouldn't that just result in some of the navel-gazing that's happening with Coalition right now? The argy-bargy of what happens in Cabinet processes around different positions of different ministers. Is Cabinet in confidence for a reason? It's a distraction. Are we not then taking that away from what the Australian people would see as the priority issue, which is the decision that is made? And that's what this bill's trying to do, that is trying to preserve some of that confidence in which that the Australian community can have around Cabinet processes, and just by labelling a document that it is a Cabinet document under these new changes in this bill would not automatically make it exempt. Do you agree?
I agree with the last statement about this legislation seeking to ensure that just because a document is labelled Cabinet doesn't make it automatically exempt from FOI. However, more broadly, the substance of this bill would, in effect, reduce the number of documents that are released, including Cabinet documents, by expanding the exemptions to documents that rather, are developed rather than having the dominant purpose for Cabinet. That would be changed to being a substantial purpose for Cabinet, and that obviously expands the scope of documents that would no longer be able to be released under freedom of information. And also the expansion...
Well, I'm not sure, Ms Crowe, how many Cabinet confidence documents you've seen or obtained through FOI, but the ones I've seen, my fixation would be more on what was the Cabinet decision rather than what's the, as part of the collective ministerial responsibility versus what were individual positions of different Cabinet ministers. So I think that, that's what this bill seeks to do, and just by labelling that document a Cabinet document does not exempt it under the changes that this government seeks to do in the amendments to this bill. But I don't want to spend any more time on that. The Home Affairs submission notes that the legislation will also increase protections for people fleeing family and domestic violence and children's custody arrangements. Do you acknowledge that the current system can put people at risk and does?
Senator, I'll probably take that last one on notice and provide a more fulsome response about that. We've not included that section in our submission, so I'd have to go through that in detail. Thank you.
Can I just ask though, like your agency, has many member organisations that deal directly with these issues. As a peak body, surely there's a position that your agency has to acknowledge that when we build systems like this has been numerous conversations, inquiries that, in fact, that this committee has led in missing and murdered First Nations women and children, for instance, that when we build systems like this, sometimes they put people at risk. Would you agree with that statement? And that's what we seek to amend.
Senator, I would note that a number of stakeholders to this inquiry have called for a wholesale review of the Freedom of Information Act as it currently stands, and I think that is because that there are a number of questions outstanding about how the current Act is operating and what needs to change to ensure that freedom of information is serving its objective to, increase and boost transparency within government.
But also ultimately protecting victims of violence, I think you would agree, should also be a factor that we play. But I'll move on to ACF if I can. Your primary recommendation is that there should be an independent review of the FOI system. Is ACF aware that we've already had 5 reviews that have considered FOI since 2012?
Yes, we're aware of that, and we've followed the outcomes of those reviews quite closely. The reason we're recommending further review is because it appears that those recommendations have not been adopted by the government in this bill, and we are hearing assertions...
Well, I reject that characterisation. There are many, many different recommendations of the Hawke Review that have been picked up and included in the explanatory memorandum and the second reading speech of the Attorney-General. She's covered some of those. So there's an assertion that's being made. But I mean, we've already had 5 reviews into this matter. I think everyone in what we've heard in the evidence today agrees that the FOI system is broken and that this government seeks to get on with the job with fixing that. So do we really want to keep having review after review and never solving this issue? Or are we just waiting for a review that actually agrees with your position?
Senator.
Is it time now to do real reform, or are we just waiting until civil society agrees that we should give unfettered access to all of that?
Senator, I don't respectfully agree with your characterisation of this bill as real reform. And for example, the government has asserted that there's a problem with bots. That hasn't come up in a single review until now. So it would be interesting to explore the evidence behind something like that. I'm really interested.
I reject that because that was covered in the previous part.
Chair, sorry, you're dealing with it. But we just allow the witnesses to finish their answers twice now. The witness has been
Thank you for that intervention, Senator Shoebridge. We are at the marker of lunch, which is 1 o'clock. I will invite the witness to finish her response to the question briefly before we break for lunch.
Sorry, everyone, that I'm left holding the baby. I'm sure there was plenty more to be said. Even, Senator, just agree to some of the things that you were mentioning with ACOS. Indigenous women and children being at risk from documents released under FOI, that's the sort of thing that really should be explored. How are personal information exemptions and public interest tests being applied now? As far as I'm aware, I haven't seen information like that in previous reviews. So that sort of thing I think would be really interesting to explore and to hear from people on the ground about their experiences. We are some of those people on the ground and our experiences are not good to date, and our opinion of that bill is that it's only going to make that worse. Thank you.
Thank you very much, Ms Shue. Thank you, Senator Cox. We will now break for lunch, but it is my job to thank you very much to each of our panel members today for appearing to give evidence to the committee. I know that some of you have been asked to provide information on notice, so would you please forward that to the Secretary by the 24th of October 2025. You'll be sent a copy of the transcript of your evidence and you'll have an opportunity to request corrections to any transcription errors. Thank you very much for your time today. We'll now suspend until 1:30 for lunch.
Thank you.
resume broadcasting, and we are returning with the Australian Public Service Commission and the Community and Public Sector Union. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses has been provided to you and is available from the Secretariat also. I remind senators and witnesses that the Senate has resolved that an officer of the Department of a Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer to questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanation of policies or factual questions about how and when policies were adopted. For the Hansard record, would you please state your full name and the capacity in which you appear?
Senator, I'm happy to go first. It's Rachel Bacon, Deputy Commissioner, Australian Public Service Commission.
And Melanie McIntyre, General Counsel and Assistant Commissioner, Australian Public Service Commission.
Excellent.
Thank you, Senator. My name is Rebecca Fawcett. I'm the CSU's Deputy Secretary.
Thank you.
My name is Osman Chu and I am the Senior Policy and Research Officer at the CPSU.
Excellent. Thank you very much. Do either of you have an opening statement?
Not from us, thank you, Senator.
Yes, I do. Thank you, Senator.
Thank you, Ms. Fawcett. Please proceed.
I would like to begin by acknowledging the Gadigal people of the Eora Nation, the traditional custodians of the land I am on today, and I pay my respects to their elders past and present and extend that respect to First Nations people joining us. I appear today on behalf of the Community and Public Sector Union, the principal union representing employees across the Australian Public Service. Our members are deeply committed to serving the government, the Parliament and the Australian public with integrity and professionalism, and we welcome the opportunity to contribute to this inquiry this afternoon. Freedom of information laws are a cornerstone of open government. They are essential to assuring transparency, accountability and public trust in our democratic institutions. The right to access government-held information empowers citizens to engage meaningfully in civic life and hold public bodies to account. There is an opportunity, now that the FOI Act is over 40 years old, to review the FOI framework and ensure it properly meets the objective of promoting open and transparent government as a foundation of representative democracy. With these democratic principles at the centre, it is also time to make changes that reflect the reality of the digital age and the increased complexity of processing requests for information. Change is needed to ensure that APS employees who are responsible for processing FOI requests are not put under unsustainable pressure and are not subject to abuse by applicants. Improvements to FOI processes would also support the integrity of the FOI framework, ensuring requests for information can be processed quickly and more efficiently than is currently possible. The CPSU recommends a comprehensive review of the FOI Act as recommended by the 2013 Hawke Review. This review should consider the Act's interaction with the Archives Act, the Privacy Act, and other relevant legislation to ensure a coherent and future-proof framework. It should also examine proactive disclosure reforms and the impact it would have on reducing FOI workloads. A review should consider best practice across jurisdictions, including initiatives to support greater access and transparency, while ironing out processes that delay and complicate the current framework. The FOI framework should continue to be weighted towards disclosure and openness and not against it. Aspects of the bill that seek to limit disclosure should be split off from the bill and subject to a comprehensive review. These proposals require close scrutiny to ensure that the objectives of openness and transparency, bedrocks of our democracy, are maintained. There are some practical and sensible changes in the bill that should proceed. These changes would improve the efficacy of the system, reduce harmful and unsustainable workloads, and reduce the exposure of FOI staff to unacceptable behaviour by applicants. The majority of FOI requests, 72% in 2023-2024, are for personal information, with two agencies, the Department of Home Affairs and Services Australia, receiving over half of all requests. Processing these requests is highly manual and resource intensive. often requiring a line-by-line review of documents for third-party personal information, verification of identities and consent from multiple individuals, and a manual redaction of sensitive content. These tasks are time-consuming and increasingly complex. Yet, FOI teams are expected to meet statutory timeframes that haven't changed since the Act's inception 40 years ago, deadlines that predate the internet and modern digital systems. As one CPSU member put it, the current 30-day timeframe is now next to impossible to meet. This is exacerbated by increasing volumes of bulk bucket list requests and a lack of additional resourcing. The CPSU supports several practical amendments that would ease these pressures, namely replacing calendar days with working days for statutory timeframes, streamlining extension processes where applicants consent, introducing a mechanism to declare specific requests rather than individuals as vexatious, and clarifying that personal and non-work-related information about APS employees is not subject to disclosure. FOI staff are under significant pressure. Legislative change and court decisions often lead to increased FOI requests, yet additional resources rarely follow. This mismatch exacerbates already unsustainable workloads. The proposed amendments, such as shifting statutory timeframes from calendar to working days and removing the need for the involvement of the Office of the Australian Information Commissioner in time extensions where applicants consent, are modest but meaningful changes. They would provide immediate relief to FOI teams and improve the system's responsiveness. FOI officers also face vexatious and repetitive requests that consume time and resources. The current mechanism to declare someone a vexatious applicant is burdensome and rarely used. Introducing a more targeted process to designate specific requests as vexatious is a long overdue reform. These challenges are compounded by the behaviour of some applicants. FOI staff have reported instances of written abuse and attempts to access personal information about APS employees. This not only wastes resources, but exposes staff to unnecessary stress and risk. These aspects of the bill would improve the safety, efficiency and sustainability of the FOI work without compromising the public's right to access information. To ensure progress that can immediately improve the system, we recommend splitting the bill into two tranches to allow staff supportive provisions to proceed. Finally, we stress that any legislative reform must be accompanied by appropriate resourcing. Without it, even the most well-intentioned reforms risk failure. This includes resourcing the Office of the Australian Information Commissioner, which has seen a dramatic increase in FOI review cases. At the same time, it has experienced a reduction in staffing. Thank you for the opportunity to address the committee this afternoon.
Sorry, I did say that while I was on mute. I said, thank you, Ms Fawcett. We will now proceed to questions and I'll go to Senator Collins.
Oh, Chair, can I just quickly note that I'm a member of the CPSU? I don't think it's relevant conflict, but I think it's appropriate that I put it on record.
Thank you for declaring that, Senator Shoebridge.
Thank you, Chair. My question is for APSC, and we have heard concerns raised about the public servants' safety and wellbeing due to the potential release of personal information under FOI. No one is, as I understand it, is calling for the release of that information, and indeed the current practice is to exclude it under Section 22, as it is not relevant. So how do those concerns justify the imposition of a cost barrier, the expansion of cabinet documents exemption, and the decision to confer the power on agencies not to even search for the documents if it is, I quote, apparent that they would exempt?
Senator, thank you for your question. Maybe just to put a little bit of context around the approach that we've taken to providing some evidence for this committee, we very much focused in on the statutory functions of the Australian Public Service Commission and the Commissioner under Section 41 of the Public Service Act. So they go specifically to things around workforce management, integrity and conduct and capability. Particularly relevant in this case are issues relating to workforce impacts and conduct. So we haven't focused as much on the list of amendments that you've run through there. Our evidence that's been most relevant to our statutory functions have been issues around deliberative exemptions, vexatious applications and the arrangements there and anonymous applications.
Okay, so just following on from that, if I may, the bill allows a department to refuse to deal with a vexatious application as opposed to a vexatious applicant, effectively meaning that you don't need to remove anonymity to refuse to deal with an improper and vexatious application. So why remove the anonymity and impose that barrier, which may, among other things, in certain circumstances, expose applicants to retribution and other adverse consequences?
Thanks, Senator. I think we'd say that those two amendments in our kind of observation can work together. So we see the amendments in the bill in relation to vexatious applicants going directly to the issues that we observe across the APS workforce in relation to harassing, intimidating and threatening behaviours. We see our observation is that those behaviours can be exacerbated, where applicants can be emboldened to exhibit those types of behaviours if their applications continue to be anonymous. So we'd see both those amendments going to address the issues for the workforce around that harassing, intimidating and threatening behaviour.
Okay. Now, one of the public service values is impartiality, which requires public servants to give frank, fearless and evidence-based advice. So, excuse me, is it fair to say that if a public service servant is not giving frank, fearless and evidence-based advice, they're not complying with their statutory obligations?
That's correct, Senator. So it is the duty of public servants, as you say, to provide frank and evidence-based advice. And that is set out in Section 10, subsection 5 of the Public Service Act. It's clear from the legislation that when those duties are not met and when the values are not followed and complied with by public servants, then consequences do flow from that. They can be consequences in the form, for example, of performance processes and performance management. They can also be consequences that take the form of code of conduct processes that are also set out in the legislation.
Okay. Are you aware of any instances of this occurring as a result of FOI?
We'd need to take that on notice, I think, Senator.
Thank you. And also if any disciplinary or administrative actions were taken in relation to the failure of those public servants to comply with their obligations, that would be great. Thank you.
Thanks, Senator. Just the one thing that I would clarify is that under the Public Service Act, agency heads essentially set up code of conduct processes and policies within their own departments and agencies. The thing we would be able to provide you with on notice is whether any of the Commission's caseload, which is a certain smaller subset of matters across the Australian Public Service that focus, for example, on agency heads, we'd be able to provide you that information on notice and take a look at that. Other departments and agencies would be better placed to provide you with information in relation to their caseloads.
Thank you.
Final question, Senator Collins.
Thank you, Chair. In your submission, you linked the FOI to pink bats. Can you please tell me how the pink bats debacle could have been avoided if this bill were in place?
Senator, what we're seeking to draw out in our evidence is the observations that have been made in successive reviews, particularly we're talking about the Thodey and Shergold reviews, about some of the unintended consequences that are flowing from the current FOI framework. So when it comes to examples of how that has manifested, what those reviews have highlighted is they've found that less advice is being put in writing and that there's less frankness of the advice that's being put in writing, and that undermines accountability and transparency. So the concern is that where policies are being formed as part of government decision-making processes, that the publication of material can inhibit those policy-making processes, and that amendments around deliberative processes would support the FOI framework to be operating as intended and enabling that frank and free exchange of opinion. So when it goes to your question, your specific question about home insulation, the general point that we've made in our evidence is the importance of public servants giving frank and fearless advice and those observations around unintended consequences that inhibit that.
Thank you. Surely that's a fair... Thank you.
Senator Lambie. Might go to Senator Shoebridge and come back to Senator Lambie.
Thanks, Chair. Thanks both for your evidence. I'm a little confused by the APSC's reliance upon the Robodebt Royal Commission and the Robodebt scandal as being a reason to actually have less access to information under FOI, and you do it at page 4 of your submission. When the recommendations of the Royal Commission were to actually make it easier to get information under FOI, and the Royal Commission pointed out in great detail how the failure to produce critical documents under FOI meant there wasn't public disclosure of the appalling lack of decency in the program much earlier. I mean, how is it that you have taken 180-degree different read of the Robodebt Royal Commission leading to more secrecy than the Commission itself or every other non-government witness? How have you come to that conclusion?
Thanks for the question, Senator. I think, as Dr. De Brouwer said in his evidence and estimates last week, we certainly accept there were many factors that led to the very concerning things that we saw in Robodebt, and there are a complexity of factors there. What the evidence in our submission is highlighting is one of many factors that contributed to that very serious set of circumstances. And as Dr. De Brouwer said in his evidence last week, there were issues raised in both the Robodebt Royal Commission and also in the Code of Conduct Task Force that followed the Royal Commission relating to frank and fearless, the provision of frank and fearless advice by public servants. So, for example, there were observations from the Royal Commissioner about a lack of written advice to ministers. The Code of Conduct Task Force final report also included an insight about the provision of advice to government. And that task force report found that the views of one department were not adequately reflected in advice to ministers at critical points.
Well, you see, this seems like a deep culture problem that's happened on your watch. You're meant to be setting standards and maintaining standards, and yet you come to this committee and you say, well, public servants are not doing what they should. They're not providing frank and fearless advice in writing. They're not putting it down. They're relying on post-it notes and Signal and WhatsApp. That seems to me a culture problem that you're highlighting and contrary to what their legal obligations are. So what have you been doing to deal with that culture problem, apart from coming here and saying, well, let's gut FOI? What have you been doing?
So, Senator, just as we talked about a complexity of factors leading to Robodebt, there are also, in our view, a complexity of factors that go to the culture that exists across the Australian Public Service. There are a number of things that the public service, supported by the Public Service Commission, has been doing in the delivery of the Australian Public Service reform agenda, the government's reform agenda, that do go to a pro-integrity culture in the public service, and we're starting to see the impact, the evidence of impact of those initiatives flow through in improvements in our census results, particularly, for example, around integrity and also around innovation, where risk is an essential part of innovation. To give just one example, Senator, of the work we've been doing to really lean in to that pro-integrity culture, which does include the provision of frank and fearless advice. There's been a concerted amount of work by the Commission, departments and agencies, a number of secretaries around instilling what we call a speak up culture across the Australian Public Service. There's a lot of guidance material. We've been promoting that with public servants right across the Australian Public Service in all departments and agencies about the importance of leadership in the Australian Public Service, of team leaders who are running teams in all departments and agencies to instil a speak up culture across the Australian Public Service where staff feel psychologically safe to raise issues, to not stand by when they see something that they're concerned about, to be able to express issues, escalate issues, and that would include, in our view, a culture that supports the provision of frank and fearless advice. So,
where is any of this in your submission when all you put in right into this committee to support, changes to FOI that are pretty much uniformly opposed in civil society? Statements such as on page 4, where you say that robo-debt highlights that the current exemptions of deliberative material have made it harder for public servants to do their duty, and the consequences of avoiding written advice about serious risks are evident in the robo-debt and home insulation Royal Commission reports. Now, I've put it to you that most people who have a fair reading of the Royal Commission would not support your conclusion on the robo-debt Royal Commission. But where is it in your submission that you point to these other efforts to actually deal with those integrity issues so that we can have a proper balanced view of what's going on in the public service? Surely your job is to give this committee a balanced view, and I don't see it here.
Thank you, Senator Shoebridge. That was your final question.
To provide that information on notice. Thanks, Chair.
No, but Chair, the question is, why wasn't it provided? Your obligation is to assist this committee and to, I would have thought, provide frank and fearless advice to this committee as much as anything else. So why did we not get any of that material, and why did we only get one side of the argument when you had all that material to hand when I simply asked the question? Can you explain that?
Senator, we've focused on the particular provisions in the bill that we understood were the focus of this committee. We're very happy to provide further detail of the type I've described and more on notice so that the committee has access to all of that information.
Thank you, Senator Shoebridge. Senator Pocock.
Thank you, Chair. Thank you for your time. Dr Bacon, I'd also like to take you to the Royal Commission into robo-debt. As you know, the Royal Commission costs tens of millions of dollars, received more than 1,000 submissions and took evidence from some 115 witnesses. The full report runs for more than 1,000 pages. And I believe on 656, this is a quote attributable to Commissioner Holmes. And I'll quote directly. It is time to ask whether the rationale of public interest immunity, the maintenance of cabinet solidarity and collective responsibility really justifies the withholding of information that routinely occurs under that mantle. Nothing I have seen in ministerial briefs or material put to cabinet suggests any tendency to give full and frank advice that might be impaired by the possibility of disclosure. Do you think Commissioner Holmes is wrong with this statement?
Thanks for your question, Senator. It may not be appropriate for me to offer an opinion, but probably what I would say is that, as I said before in our evidence, we're very much focused on the Commission's statutory functions and the things that are most directly relevant to those statutory functions. And so that's why we've provided some evidence of our observations around things that are impacted by that deliberative exemption. We haven't gone so far as to provide evidence in relation to cabinet exemption specifically.
Mm-hmm. I'd like to read another quote from Commissioner Holmes in the same report. What has happened in the case of the scheme demonstrates the need for greater transparency for cabinet decision-making. That raises the real question of whether the protection of cabinet documents as a class from disclosure ought to be maintained, or whether, when access is sought, disclosure should be given unless there is a specific public interest in maintaining its confidentiality. The report goes on to recommend repeal of Section 34 of the FOI Act, the Cabinet document exemption. I'm interested if the APSC believes that the exemption should be repealed in line with the final observation of the Royal Commission or expanded as this bill proposes.
Senator, if you'll forgive me, I might defer that question to colleagues from the Attorney General's Department who have been working on the policy on the bill.
Sorry, Dr. Bacon, I'm interested in the APSC's view on this, given I guess you're sort of in charge of enforcing standards in the APS.
So we've gone, as I said before, we've gone to issues that we think particularly impact on our statutory functions around workforce management, around integrity and conduct. The elements of the bill that we see have the closest connection to our statutory functions really go to things around the deliberative exemption that we, in our observation, does have implications for the conduct of public servants for the reasons I've talked about a bit earlier. We see the amendments in relation to vexatious and anonymous applications in particular going to those workforce impacts. So we have focused on those issues that are most relevant to those statutory functions.
In your submission, though, you speak to the interaction between the deliberative exemption and frank and fearless advice. What about the relationship between advice and cabinet confidentiality? It seems to me that the APSC has taken a very different view to the Robodebt Royal Commission report.
I think what I'd say, Senator, is we haven't expressed a view in our evidence around the cabinet exemption issues.
Could you explain why?
We have, because we've sought to focus on the issues that are most relevant to our statutory functions. And sorry, I don't mean to repeat myself. I know that's frustrating.
But, sorry, you don't believe that part of this bill is actually relevant to the APS?
We think it's probably more relevant to the way in which cabinet processes are conducted and cabinet processes run, which is more the purview of the Department of Prime Minister and Cabinet.
Okay, so not relevant to the APS. I'm interested to come back to something that Senator Shoebridge was asking about, and I've actually found this really troubling since the Robodebt Royal Commission and the APSC's response to this, where something like record keeping and putting things in writing, to me, really is a cultural thing, and it should be something the APSC is actually enforcing. Recommendation 23.8, documenting decisions and discussions. The Australian Public Service Commission should develop standards for documenting important decisions and discussions and the delivery of training on those standards. I'm interested what has happened there, and how can you have that as a recommendation from a Royal Commission and then come here and argue that, well, actually, if you make it harder to access information through FOI, then we'll maybe just be able to do our job?
So maybe I can explain, Senator, thank you for the question, what the APSC has done in relation to record keeping and how that kind of goes to that recommendation from the Royal Commission. So as you'd be aware, Senator, the new value of stewardship under the Public Service Act, that came into force on the 11th of December last year. The APSC has the responsibility to issue directions to all public servants on compliance with the values under the Public Service Act. So we updated the Australian Public Service Commissioner's directions. They were 2022 directions. We updated those directions to reflect the introduction of stewardship as a legislated value, and that updated direction came into effect on the 11th of December. We also provided guidance in advance of those things coming into effect that go further to the stewardship value and how it applies in practice. The direction on stewardship explicitly refers to the record-keeping obligations of public servants. So if I could draw your attention to section 17A, paragraph E of the directions, it sets out the requirement for public servants to ensure complete, accurate and appropriately accessible record keeping of key actions and decisions. So in our view, it's that updated direction in combination with the legislative amendment and also operating in combination with pretty extensive guidance from the National Archives, that in combination delivers on that recommendation 23.8 that you were talking about.
But, no, Senator Pocock, final question.
Final question. Dr. Bacon, surely this is about accountability, not stewardship. And I'm interested why this value is under stewardship and not accountability, and not actually in line with what the Robodebt Royal Commission really seemed to lay bare. I think it's just such an amazing opportunity for us as a country, and I'm interested how you landed on this being about stewardship and not being about accountability.
So it goes, Senator, to the definition of stewardship under the Act. So, and that's where the link to record keeping is really teased out. So I'm looking here at section 10, subsection 6 of the Act that talks about stewardship. And the definition there is that the APS builds its capability and institutional knowledge and supports the public interest now and into the future by understanding the long-term impacts of what it does. The point about institutional knowledge is really the capturing of that institutional knowledge that is part of that legislated value around stewardship that we see as having direct links to record-keeping obligations, because it's through proper record-keeping. And your point about culture, we entirely agree, Senator. Culture is a very important part of making sure that we lift standards on record-keeping across the service. It's that link to institutional knowledge and record-keeping and keeping records for the future stewarding of issues by the public service. That's what our guidance seeks to tease out.
Thank you, Senator Pocock. Senator Cox.
Thank you very much, Chair. Can I continue the line of questioning with the APSC? This committee spent some time today really talking through the impact for public servants, and just noting in your submission that, you know, the examples that we've been given, Services Australia, Home Affairs, that have appeared already today is really around some of those examples of threats and violence and harassment and intimidation towards public servants. Can you give us any examples, or have you had any reports, or do you see any improvements in relation to what this bill seeks to do to protect public servants who, particularly under the circumstances of anonymous applications of or requests for FOI may have? And I want to sort of, I suppose, articulate to the committee the impacts of that.
Thank you, Senator. Unfortunately, yes, we do have examples that agencies have provided to us that I'm able to share today. Agencies have seen behaviours such as the posting of personal information, including photographs of agency staff and their children, on publicly available blogs in posts that appear to be designed to distress them. They have searched for details of agency staff members' previous employments and then put in FOI requests relating to their job application. And because you have asked this question, I will read out a quote of a type of harassing statement that has been made to a public servant as follows: "Just because your feelings are hurt doesn't absolve you of your legislated obligations. I could, not that I would do this. This is not a threat. I would not do this. I'm just trying to explain the concept. Come around and stab any one of you, and you would still have to action my claim as per the legislation. Being offended or getting stabbed or anything like this is not a reason to fail to perform your duties." And these kinds of examples, Senator, often the people that are processing FOI requests are junior staff. That's how we're structured in my organisation. And so the proposal in the bill to be able to protect staff by declaring requests vexatious and requiring evidence that a request is coming from a person who's identifying themselves will mean that there are additional ways that the agency is able to keep a workplace that is free from the psychosocial risk of harm and the hazards that can occur from being in a workplace where this kind of content and behaviour is appearing, particularly towards our junior staff members.
And Senator, just to add to Ms McIntyre's evidence and go to your question about impacts and expand on that a bit more. So the types of threatening, harassing and intimidating behaviours that Ms McIntyre's referred to, we are seeing impacts on staff across the workforce subjected to these types of behaviours, and those impacts would include psychological distress, elevated anxiety, depression, PTSD-like symptoms. Workforce attrition is another consequence. That then has follow-through effects at more an organisational and a service level. So we see impacts around service degradation, and it also has consequences for organisational liability. So they're the types of impacts that we see from flowing from these types of behaviours.
Thank you very much for articulating that. And I just want to note Ms Fawcett did mention some of that in her opening statement. So I just wanted to include you in this line of questioning. I've only got a short amount of time, but your submission also notes that you support some of those positive changes, particularly around the protection of public servants. And can you just expand on some of that with examples possibly? I know that you did articulate or touch on some of those, but are there any further contributions that you wanted to make, Ms Fawcett?
Thank you, Senator. Yes, our members do raise growing concerns with unacceptable behaviour by some applicants. There is a growing workplace health and safety concern around increased aggression from some applicants, frustrated by FOI delays because the system is under pressure and often caused by high workloads. So in some cases, we have seen applicants request staff's personal information, their login details, and other personal information that is completely inappropriate to provide. So for that reason, the CPSU does support a much clearer and more straightforward process for an agency to determine that an applicant is vexatious, rather than the complicated process that exists at the moment whereby the determination must be made by the Office of the Australian Information Commissioner, and it's a long process that's rarely used because it is quite cumbersome. So we do support that change. Thank you, Senator.
Thank you, Ms Fawcett. Can I just ask quickly, I know that I will be out of time very shortly and the Chair will need to share the call, but the APSC, can you just outline for us why you consider the deliberative exemption in the FOI process, why this needs to change?
Thanks, Senator. So I think also as the Commissioner has gone through evidence at estimates as well, there is a duty on public servants to provide frank and evidence-based advice, so that's set out in the legislation. We've talked a bit today about the consequences when those duties are not met, like performance management processes or code of conduct investigations. Despite the duty that's very clear in the legislation and the consequences of failing to comply with that duty, there have been unintended consequences from the current FOI framework that have been observed in reviews like the Thodey and Shergold reviews. And those reviews point to changes from 2009 to the FOI framework, also the narrowing over time of what deliberative material means. And so those reviews have found that less advice is being put in writing and that there's less frankness of the advice that's being put in writing, and that undermines accountability and transparency that are important features of the way the public service should be operating. So that's essentially I guess, the basis for the evidence that we've given around that the changes to that deliberative exemption, Senator.
Thank you very much, and thank you all for your evidence today. I'll hand it back to the Chair.
Thank you very much, Senator Cox. I want to thank witnesses for taking the time to give evidence today. If you've been asked to provide any information on notice, and there will likely be questions on notice given to you also, would you please forward it to the Secretary by the 24th of October. You will also be sent a copy of the transcript of your evidence and have an opportunity to request corrections to any transcription errors. Thank you very much. We'll take a quick 1-minute suspension while we welcome our next witnesses. I now welcome representatives from the Australian Press Council, the Media, Entertainment and Arts Alliance, and the Alliance for Journalists' Freedom, and Dr. Danielle Moon. Thank you for taking the time to speak to the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is also available from the Secretariat. For the Hansard record, would you please state your full name and the capacity in which you appear? We can start with the Alliance for Journalist Freedom and Dr. Danielle Moon. Maybe I'll start at the bottom of the right screen for me. Dr. Moon.
Dr. Danielle Moon. I'm speaking on my own capacity, but I work as a lecturer at Macquarie University. And I believe Peter Grass is in the room, and our submission is a joint one.
Thank you. Media, Entertainment and Arts Alliance.
Good afternoon. My name is Adam Portelli and I'm the Deputy Chief Executive of the MEAA.
My name is Ben Butler. I'm a member of the MEAA, a journalist at the ABC. I appear in my capacity as a member of MEA.
And my name is Royce Chalmers. I'm a freelance journalist and author.
Thank you very much. And then the Australian Press Council.
Oh, yes. Hi. Good afternoon. I'm Yvette Lamont, the CEO and Executive Director of the Australian Press Council.
Thank you to each of you. Now, do any of you have an opening statement that you'd like to make?
Yes, Senator,
yes.
we do.
Yeah.
Okay, great. We'll start with the Media, Entertainment and Arts Alliance.
Thank you, Senator. The Media, Entertainment and Arts Alliance, MEA, welcomes the opportunity to make a submission into today's inquiry. With me are two working journalists, Ben from the ABC, who's also worked at a number of media outlets over the years, including The Guardian and Australian, and Royce, who is a freelance journalist and author whose work appears regularly in Drilled, The Guardian, The Saturday Paper, Rolling Stone and Al Jazeera English, amongst others. Both have extensive experience in dealing with federal FOI systems and can speak shortly to and answer questions from the committee about the challenges the system currently presents and the additional issues the bill's proposals would present not just for them, but for public interest journalism. By way of background, our organisation, our union, represents over 16,000 workers in the media and creative fields and around 5,500 workers in the media and journalism space. These professionals come from all parts of the industry, public and commercial, broadcast, print and digital, medium, small and large. Importantly, about a quarter of our media membership are freelance journalists. And for our journalists, our members, FOI is of course a crucial industrial issue, and it's also a vital one of press freedom. There are a range of matters the committee has seen, a range of matters of public interest referred to in many of the other submissions, including ours, that have only been made public thanks to journalists utilising FOI. So we know how important it is. We also know the serious problems that FOI has, including the growing volume of requests and the ever-ballooning response times. The bill, however, from our perspective, rather than looking to the root causes of the system's problems, including the lack of staffing and the lack of proactive disclosure, takes what we see as a punitive approach that serves neither the Australian public or this country's journalists. The bill proposes measures that would introduce an application fee for FOI requests, which would actively discourage public interest journalism, particularly for freelancers who already struggle to earn a living. It would seek to ban anonymous FOI requests and requests using pseudonyms, despite such requests we know being critical to allowing public servants and others to bring light misconduct where it occurs in agencies. Proposes measures that would introduce a blanket refusal to applications taking more than 40 hours to process, something our members feel, our members know, would be used to refuse all but the most basic FOI requests. It proposes measures that would give agencies the power to reject requests deemed vexatious, abusive or frivolous, despite such mechanisms already existing. And it would seek to expand the already wide, in our view, cabinet document exemptions, threatening transparency further. It of course makes a number of further proposals that have generated significant concerns in other submissions. MIA cannot support this bill in its current form. It would, if passed, have the effect of further restricting Australians' access to government information. Instead, we urge the federal government, to review FOI in a comprehensive way that includes proper consultation with all the stakeholders, including, of course, the journalists and their union. And we ask the government, instead of the proposals outlined in this bill, to focus on better resourcing and proactive disclosure. Thank you to the committee, and I know Ben and Royce would like to provide some further insights into the way in which the FOI system already unduly restricts their work and the way in which these proposals would practically impact journalists, as well as, of course, to answer any of your questions. Thank you.
Thank you very much, Mr. Portelli. Ms. Lamont.
Thank you. So the Australian Press Council thanks the committee for this opportunity to appear today and highlight the material that we provided in our written submission. Our submission raises several areas of concerns with the FOI Amendment Bill, which we believe do not support timely access to information that journalists require to undertake their important work. The Press Council, as you're probably aware, is the principal body responsible for preserving freedom of the press in Australia, and has long emphasised the importance of access to government-held information as a cornerstone of democratic accountability. The operation of a free and open press is an important foundation to Australia's democracy. A free press ensures the public is properly informed on matters of public interest. An important role of public interest journalism is holding governments and decision makers to account for their decisions and actions. An effective FOI framework ensures that journalists and the public can scrutinise decision making, hold institutions to account, and strengthen trust in government. The existence of effective FOI laws is an important input to the ability of news media to fulfil its role. However, the mere existence of laws is not in itself enough. The way laws are administered and implemented are of equal importance. It is critical that the FOI laws are applied in a way that promote the express objects of the legislation. The key principles of FOI and press freedom. So the Press Council has consistently maintained that FOI laws must reflect three key principles. Firstly, a presumption of maximum disclosure. Secondly, timely and affordable access. And thirdly, independent and well-resourced review mechanisms. So areas of primary concern to the APC are that we do have identified some serious risks that the bill in its current form could undermine transparency. In relation to exemptions, while exemptions are a necessary safeguard in limited context, the bill does not adequately constrain their scope. So broadly defined exemptions for cabinet documents, deliberative processes, national security and commercial in confidence have historically been applied sometimes far beyond their original intent. For example, cabinet confidentiality has been invoked to withhold entire classes of documents, even when only part of a paper genuinely reveals cabinet deliberations. Similarly, commercial in confidence has been used to block scrutiny of major infrastructure contracts, despite strong public interest in accountability for public expenditure. The bill risks entrenching secrecy and allowing exemptions to be misused to protect governments from political embarrassment rather than legitimate confidentiality. Delays is another issue. So the effectiveness of the FOI depends not only on access but on timely access. Delays remain systemic. Reports by the Right to Know Coalition documented requests taking more than 2 years to resolve, rendering the information obsolete for public debate. The Office of the OAIC has also acknowledged growing backlogs. The bill's inclusion of longer statutory deadlines and a 40-hour process cap are not helpful in this regard. In relation to costs, access to information is a fundamental democratic right and should not be contingent on financial means. Application and review fees pose a significant barrier for freelance journalists, smaller outlets, academics, and civil society groups. Individuals are far less likely to pursue applications and reviews when fees are imposed. We believe the bill misses an opportunity to embed proactive disclosure by requiring agencies to publish classes of documents such as ministerial diaries, contracts over a threshold, and final reports of significant inquiries. The demand for FOI would be reduced at its source. Jurisdictions like Queensland have already demonstrated that routine publication of ministerial diaries can enhance transparency and lessen administrative burdens. Without such obligations, reliance on FOI requests remains heavy, perpetuating backlogs and delaying access. Proactive disclosure shifts the balance from secrecy by default to transparency by default, aligning with international democratic standards and enhancing public trust. In conclusion, the freedom of information regime is essential to the functioning of Australia's democracy. While the Press Council supports efforts to modernise FOI laws, the bill in its current form risks perpetuating delays, excessive secrecy and inequitable access, and appears contrary to the obligations under the FOI Act to facilitate and promote access to information promptly and at the lowest cost. The Press Council, therefore, on balance, recommends that the bill not be passed in its current form. Thank you.
Thank you very much. And Dr. Moon, confirming you're on mute.
Oh, sorry. I believe Professor Grest is in the room and is going to give the opening statement on our behalf.
Oh, Professor Grest.
Thank you very much, Senator. As with my colleagues, we'd like to thank the committee for inviting us to provide evidence today at this important inquiry. This is important for journalists and for the public who have both a right and a need to know what the government's doing. Now, we commend the government for recognising this and for addressing enduring and complex tensions between access to information and government efficiency. And we agree that the current framework is complex and burdensome, both for those seeking information and those tasked with providing it. We firmly agree that the current system is overdue for reform, and we're grateful for the opportunity to contribute to this process. And I also want to commend the government for creating unanimity amongst the media, who are usually fiercely competitive. It's rare that we get a common sense of purpose and complete agreement, but I would like to say that I do agree entirely with my colleagues who've already been speaking. I've read their submissions as well. We have significant concerns about the way the proposed bill tries to address these issues. While it may alleviate some of the administrative burden on government, it does so at the expense of transparency, and in our submission, this is neither desirable nor necessary. The committee has our detailed written submissions, and we've heard some details from my colleagues already. And we're very happy, of course, to respond to any questions, but I'd like to highlight a few key points. The authors of the submission, myself and my colleague Dr. Moon, represent two very different perspectives. The Alliance for Journalist Freedom is naturally concerned about the limitations the proposed bill will place on journalists reporting on public interest issues. Dr. Moon, who joins us by video link, brings us is a former public servant, both in the UK and Australia. Her PhD focuses on the public service perspective of the very law that this bill seeks to amend. Despite these different professional perspectives, we are united in our view that the proposed bill represents a significant step backwards for Australia. If it gets passed, it will place us out of step with modern democracies around the world. Transparency is not the enemy of good government, quite the contrary. To give just one example, greater transparency would likely have prevented the excessive political responsiveness that made robo-debt possible. The devastating social and economic consequences of that are now well known. Openness facilitates accountability and in turn earns public trust. It reduces the government's vulnerability to corruption and poor policy. Now more than ever, it is crucial that members of the public can access information in a social media landscape increasingly overshadowed by misinformation, disinformation and conspiracy. Government has the opportunity to serve as a vital source of truth. Failure to take this opportunity comes with significant risks. That is not to underestimate the administrative and financial burden that FOI currently represents. But these problems aren't caused by transparency itself. They are the result of a lack of genuine political support and inefficient and overly complex access mechanisms. This is where reform should focus. It is possible to reduce the administrative and financial burdens of FOI without compromising access to information. 15 years ago, the Labor government amended the FOI Act to prioritise disclosure. The current bill signals a worrying reversal of that commitment, one that will inevitably flow into public service culture and encourage greater secrecy. We urge the government to reconsider the direction of this bill and to commit instead to more proactive disclosure, better use of technology, and a renewed focus on a system that is not just inefficient, but also reinforces the foundational democratic principles of openness and accountability. Thanks.
Thank you for the opening statement, Professor. We'll now proceed to questions, and I'll go to Senator Ghosh.
Here today and for your opening statements. My first question goes to the Australian Press Council, and having heard some of the criticisms that you've made in the opening statement about the current FOI system, would you agree that the system overall is broken, essentially?
It certainly, I don't know whether broken is the right term, but it does absolutely need a lot of help.
Okay. And taking your earlier remarks about delay, and that your submission refers to systemic delays in the FOI system. From your members' perspective, what are the main causes of those delays, and are you able to elaborate a little bit on their experience of using the system?
I would have thought that MEAA may be in a better position to elaborate on exact examples, but I do know that communication is often a big issue, and sometimes even applications aren't even acknowledged, or some time is taken to acknowledge them. So I think communication is a big part of it. But I don't know if the MEAA would like to elaborate, or some of the journos on their experience.
Senator Ben Butler, if you're happy for me to pick this up,
yes, please.
I'd love to talk to this. It's one of my particular focus.
Thought so.
So to start with, just picking up on your first question, is the system broken? I think it's teetering. The FOI system in Australia is teetering on the brink of uselessness, and this legislation is really, pretty likely to tip it over into uselessness. In terms of delays, as the Press Council talks about delays of as long as 2 years or more, I've experienced a delay quite recently of 5 years. So that's an FOI application lodged in April 2019, an Information Commissioner decision on the 13th of February 2024, a third-party appeal to the AAT that was finally finalised by consent on the 6th of August 2024. So a more than 5-year delay from start to finish to obtain one document. So delay is absolutely routine in the system. The current strategy that I employ is to attempt to get to the agency refusing the FOI as quickly as possible, because it generally does, or make a decision as quickly as possible so that we can move up before an independent decision maker as quickly as possible, the Information Commissioner or the ART. That is often where we see additional delay, because those organisations are often not resourced adequately to deal with the volume of applications. That case I just took you to, the 5-year delay, that was at a period where there was basically a complete standstill in Information Commissioner cases. I will say they have started moving again now, and they've adopted some case management strategies that are very helpful. But nonetheless, it remains a very, very slow process, both at the agency level, where you are dealing with, frankly, conflicted, or by definition, conflicted decision makers. They are at the agency where the information is going to be released. Sometimes they are people whose information will be in the documents that are released to you if you're successful, and at the level where we get an independent review of those decisions, the Information Commissioner or the Tribunal.
Thank you. Can I ask, how would faster FOI application processing assist in investigative journalism, or how important is it to investigative journalism? And I'm also happy to hear from the Alliance for Journalists' Freedom on this, because I'm sure you're also concerned with it.
So, Senator, at the moment, you essentially need to count on a FOI being historical by the time you receive it. So it is of really no use in a breaking news type situation, something that's happened recently. If you want to be within the news cycle on that, or where people might remember it without needing to be prompted, it is basically useless for that purpose. So in essence, what I tend to do is I look for things that are historical, because I know that it's going to be quite historical by the time I finally get something from the agency. So we're talking periods of years, basically. That said, it is a crucial technique that we use when examining especially the actions of enforcement agencies. ASIC is a routine FOI target for these kinds of things. Other enforcement agencies as well, law enforcement powers, to scrutinise how they've conducted themselves in relation to issues of public concern, large-scale corporate collapses, the conduct of Australia's big banks, the broader financial services industry, corporate governance, these kinds of things. So it is something we do routinely use to hold government accountable for its actions or its inactions, but it is really afflicted by those really, really long delays.
And sorry, Senator, if I may pick up as well on some points that Ben made, there are two issues, which is not just in terms of the speed of applications, but also the content and quality of applications. It is no use having rapid turnaround applications if you receive one document that is completely useless and not what you asked for. In addition to that, I am also aware of examples, not in the Commonwealth jurisdiction, but in other state levels, where applications and agencies have appeared to use the delay process to blunt a news story, knowing that this process taking a long time, directing a reporter to try to obtain information from Freedom of Information, and knowing that that process would be subject to several appeals and possibly months, if not years in the future, deliver a result, and by then the story will be dead and buried. And I believe what this speaks to is a deeper culture of attempting to, essentially, in some cases, misuse provisions of the legislation that goes back to the previous question, which was, is this system broken? I think it depends what you mean by that. I think if we think about a system, if a system a system's purpose is what it does, and if the purpose of the system is to disclose, it is not working. If the purpose of the system is to keep things from being disclosed, I think it is doing a pretty good job.
Senator Ghosh, yeah, I'd agree entirely with what my two colleagues have already articulated. I don't think there's too much else to add, except that news by definition is something that is timely. I think it's probably a little bit too much to expect an FOI system to create, to be able to generate or release information in time with the news cycle. It just moves far too swiftly for that. But gaps of years is simply not workable, particularly when we end up with changes of government, in some cases several changes of government between the application being made and the information being received, and that's just not functional. It's not workable. And as we've just been hearing from Reece, we know two of examples where the system has been played by government agencies to frustrate the flow of information rather than facilitate it. And not because there is necessarily a legitimate reason for not disclosing the information, simply because they'd rather that information not be in the public domain.
And if I could stay with you, Professor Grest or Dr. Moon, thank you for your submission, and I note that it recognises it states that the system is dysfunctional and needed reform, and there's a rare commendation of the government for its willingness to engage with the significant issues that beleaguer the system. I am interested to know your views on some of those key problems, or if there are any of the key problems that you haven't addressed so far in your evidence, and some of the solutions that you see to those problems.
I'm going to invite Dr. Moon to speak to that.
Thank you. I think the key problem really that underpins all of this is the one-sided nature of these amendments. So as we said in our evidence and in the opening statement, there is a problem of complexity and burden on the public service in responding to requests, but also on applicants making requests. It's very complex, very time-consuming, and even as someone who has both worked in the public service and is very familiar with the legislation, I myself made a Freedom of Information request that took over a year to get a response to, and I think I could only navigate the complexity because of my experience. So I don't know how useful it is for average citizens, as well as for other interest groups and journalists that might want to use it. And I think that while the bill is addressing some of the burden and complexity for the public service, it's doing so at the expense of transparency. And I think that there are other ways that this could be done. I've read the submission from Professor John McMillan, and I share his view that we could suggest, and we have suggested in our evidence, some possible changes, not least just implementing some of the recommendations that the Senate recommended 2 years ago. And there are other changes that we could make. But I think underpinning all of this is the fact that we're in a new landscape now. There's new technology, there's new complexity arising from the type and scale of requests. And I think I'm wary of suggesting knee-jerk specific changes. I'd rather there be a wholesale evidence-based reform that looks at these issues from all sides, yes, addressing the needs of the public service, but also addressing the needs of requesters, and just strikes a better balance. I personally think that one of the biggest issues that we have with FOI is the adversarial nature of relationships that underpin it. It's not a collaborative process trying to get information from government, and I would really like to see a collaborative approach to creating and designing a system that works better for everybody.
Thank you very much. Yes, Professor Grest, just very quickly.
Very, very quickly. I was just going to make the point that there seems to be an assumption that there's a hostile relationship between government and FOI requesters, and to be clear, that isn't always necessarily the case. I made a request for information regarding my own case when I was in prison in Egypt, and I was writing a book, and I wanted to support the government's involvement. It took me 2 years to get that information, by which time the book had been written, printed, published, and we'd moved on. And so, again, it's not always a hostile relationship. I think that's worth emphasising.
No, thank you. I really appreciate those answers. I think the improvement of the speed and quality of responses to FOI requests is a very valuable goal. And I think at least in my experience, it often takes resources. So I think in that sense, I do see the benefit of an increase in the fees or the payment of modest fees if that facilitates those two goals. But I will have to hand over the call at this point to Senator Stewart. Thank you, Chair.
Thank you, Senator Ghosh, and I'll go to Senator Collins.
Thank you, Chair. This is a question to everyone who is giving evidence today, and thank you very much for your evidence as well. Do you consider the bill should be passed in its current form?
There's a very short answer to that. No.
No, Senator.
As we've indicated, Senator, no.
Thank you. Does anybody consider that it should be outright rejected as it stands? So should the Senate reject this when it comes to the floor?
Yes.
Yes, Senator.
My view would be yes.
Thank you. I'd love to hear from you again. I know it has been raised throughout the evidence today, but I'd just love to hear from all of you about what you think the impact would be of the cost barrier for journalists.
Senator, it may be worthwhile my colleague speaking to this. As a freelance journalist, I think it's pretty pertinent to the question.
Absolutely. I'm happy to take the question. I think it's a very important question, particularly to do with fees and charges. I mean, there are several aspects to the proposed amendments that would propose increasing the charges associated with the applications. And I should note as well that just up the top, when we're discussing the issue of resourcing and fees and charges, that especially when you're working as a freelancer, you do not have access to lawyers or legal teams or institutional support in making these applications, and neither are you generally allowed in Australia to expense the costs associated with making an application upon delivery of a story. So that's just part of the cost of doing business, it's considered. And I can illustrate how this works by reference to two examples from the current system, and I'll start with actually one from a different jurisdiction, the state of South Australia. This is an application that I currently have on foot. It's one moment. Yes, it's currently with the Department of Energy and Water in South Australia. And after I made the application, I received a letter from the department, not a charges notice, by the way, but something that said, based on their preliminary guesswork, that the total charge for processing the application would amount to in the region of $16,629.60. So to repeat, that's $16,629.60. Now, to be clear, that was not a charges notice. That was not a demand for a deposit. That was purely a calculation based on an estimate and what behavioural economics would call a nudge. The idea was to get me to narrow down the scope of the request. And just to put this in perspective, the average Australian freelance journalist will make about 80 cents a word, depending on where they're selling. It varies, but we'll use it as a benchmark. And this means that once you put an application and draw the application and get the documents back and then go through the process of selling that storage and application, you will be earning, for a 600-word news report, you are likely to earn about $480 on that application. So if I were ultimately to pay that full $16,000, to your processing, I would be out $16,149.60 to pay the South Australian government for the privilege of doing my job. And then a second example on this is actually a pretty good example of the cost associated not just with the monetary cost, but also the time associated with this. Another application I made to a Commonwealth government agency, who I won't name because we got a good result in the end, so it ended up well. I was charged a deposit of $873.42 for access to documents. And this is on an issue of significant public interest that I have covered to some extent. So I was working in that area. Now, I was successful in overturning the decision to impose that charge and ultimately received a full 36-day refund when it was waived on public interest grounds. But this, in my experience, is unusual. Typically, when those charges are imposed, they're not waived until the appeal ultimately gets to the Information Commissioner many months or even years later in some cases. So what that means is over this period, not only did I need to have, and I did pay that money up front to keep that application on foot, not only did I need that money up front, but I also lost the use of that money over that period. So you're incurring an opportunity cost. I would note as well that just for a point of comparison about what that means, I just looked up the cost of median rent in Sydney for a two-bedroom unit right now, and according to SQM research, it's about $736 a week. So that kind of gives you a benchmark of where this goes. And so, looking at the amendments, I understand that there are just parts of the process would be to always propose to impose, give the authority to impose charges at various stages of that process, particularly not just on the initial application, but also if you would like to make an application to appeal internally and externally, particularly if you feel that a decision was wrong. And so, when you're working out outside an institution where you're reliant on those commissions and to keep a certain volume coming in, at a certain point it becomes unworkable for you to even attempt this. It's and it actually makes it harder to do my job. To inform the public about the decisions that are taken in the public, for the public, and the reasoning behind those decisions.
May I add just very briefly, I know that we need to be brief. I think what this comes down to, and obviously I'm coming from a slightly different perspective, but it comes down to what is the relationship between fees and charges and the application. Is the government seeking cost recovery? Is it seeking to cover all of the cost of responding to requests or not? And there's not really any clarity about what the purpose of fees on top of charges is, and that's always been the case since FOI was first introduced. The purpose behind them has never been clear, but the implication appears to be that, yes, it's a very expensive system, and so the government should be able to recoup some of the cost of that from the people applying, suggesting that it's more of a service that the government's providing access to this information. I would suggest we should be thinking of freedom of information and access to government information generally as one of the costs of democracy. And just as we don't charge people to vote, we shouldn't be charging people to access information.
Yeah, I mean, extraordinary, isn't it, that, $16,000 to access important information, and imagine all of that were passed on to just do a story. I appreciate that evidence that you gave, Mr. Kermelovs. It really did bring it to life, just, how difficult and costly it can be to get these stories out there for the Australian people. Thank you. Did anybody else want to add to that question?
Senator, I think Mr. Butler would like to say a couple of words, but before he does, I just emphasise that while this is particularly, the cost issue is particularly one that affects freelancers, we need to recognise the entire media landscape has undergone significant structural reform over recent years. It's under significant pressure, and it is not just freelancers who are facing that pressure. You would have seen a submission from Crikey, which is a very important, smallish media outlet, or not so small actually, media outlet, that submitted this amendment will likely affect its decision-making in the future, whether or not to pursue certain stories. So this is a really big deal for journalists more generally, not just freelancers.
Thank you. And I'll just flag I'll need to rotate the call in less than a minute. So if you could please be brief to allow Senator Shoebridge time to ask his questions too.
Senator, just to pick up on what Dr. Moon was saying about, is this a service? Is it cost recovery? What's the purpose of these fees? It is somewhat difficult in an employed journalist context, which is where I've spent most of my career, to get editors to understand that I want them to approve a payment for documents that may or may not arrive, and that we are just going to send potentially thousands of dollars into the ether with no response. As Adam says, budgets are really tight, in all newsrooms. The idea that large media organisations have heaps of money is a little bit of a lot of a fiction, actually. One very quick example, a few years ago, ASIC tried to charge me $4,380 for access to documents relating to their drafting of media releases. It turned out when I got the documents that they had been allowing the Commonwealth Bank to edit their media releases about disciplinary action against the bank, and that was the purpose of the request. They didn't want to give those to me, and I ended up having to go to the Information Commission to get that charge waived, which they did. And what that also exposed is an existing problem where record keeping can be very poor, and the cost of bad record keeping in the public service is attempted to be passed on to us, which is contrary to the current Act. So it doesn't require reform; it requires, administrative action within the service.
Thank you all. Thank you, Chair.
Thank you, Senator Collins. Senator Shoebridge.
Oh, thanks, Chair, and thanks everyone for your assistance today. Probably starting with the MEAA, but anyone should feel able to chip in. One of the things the government has been saying is, it's now taking 1 million hours of public servants' time to process FOI complaints. I know from my office's experience, we often are mystified by how much time is spent redacting things because they're said to not be relevant, or to make up confected arguments for why things should be held secret, or to spend forever contesting points that we would never contest, such as removing basic identifying information such as emails and like. Do you reckon we're getting bang for the buck for the 1 million hours that public servants are spending editing, redacting, and not disclosing?
I'll go with this one. So thank you, Senator. We are not. I too struggle to understand the estimates that we receive of time that's going to be taken to deal with documents. My feeling, and I admit this is anecdotal and based only on 10 or so years of experience dealing with this system, but is that the estimates of processing times for the same kinds of requests have increased over time without any real explanation of why it's suddenly become, or over time it's become harder or more difficult or more lengthy to deal with redacting or considering documents, where I think this is a really important issue in the context of this proposed 40-hour cap, which I don't think I've done a request. I may have done, but it would be rare these days to do a request where they come back with an estimate under 40 hours that is of any substance whatsoever. If you're asking for more than one document, if you're not identifying a document by its title and the date it was produced, you're going to get an estimate of more than 40 hours these days. So I don't have a great deal of faith in those times that we're given.
Yeah,
and
just to stop you there. When we're talking 40 hours, the government is telling us apparently that it takes them a week to process a fairly standard, not tiny, but fairly standard FOI application. I mean, it seems to me extraordinary that they don't have more efficient processes, or more attention hasn't been paid to what often I think is a scandalous amount of time being spent preventing information being released. I mean, can you how often are they saying to you that it's going to take them a week or more to process a pretty standard FOI?
Well, I'm surprised to hear that you're getting responses of any kind within a week. I'm routinely being asked for additional time past.
No. To be clear, the actual response takes weeks or months, but they tell you that they're spending a week of their time over the course of 1, 2 or 3 calendar years processing the FOI application.
Yeah, I don't understand it, and I think one of the things that our position is that, picking what Dr. Moon was saying, that this needs a proper review where we hear from stakeholders and actually try to understand what's actually going wrong with the current system, because I don't understand where these estimates come from. No.
Professor Grest, you've been doing this for a while. If you think about FOIs you might have lobbed in in 2012 compared to what you're hearing from your colleagues and yourself now in 2025. What's your reading on that trajectory of bureaucratic response?
Senator Shoebridge, I completely agree that there's something dysfunctional. I mean, I think if there's one thing that the government's claims of time that these things take reveals, it's partly that the FOI system is broken, but it also speaks very strongly to the failure of the record keeping and document tracking system within the government. And if anything, what we should be talking about is improving that system rather than FOI, because as we've seen in plenty of other jurisdictions where disclosure logs are managed, where we see routine disclosures, where we see much better systems of keeping track of documents so that it's possible to know what documents exist, even if you can't see what's inside them, for members of the public to see very clearly what documents are there, then those systems are established and available. And and as I said, I think what we should be talking about is fixing the government's record-keeping system if it is, in fact, as inefficient as they say.
And thinking back on the evidence we got earlier today from Home Affairs and Social Services, they're each of them saying they have, 10, 20,000 FOI applications a year for people's personal information. And they're churning those applications through the FOI process and spending, countless hours of bureaucrat time on it. When if they're having those routine applications for people for their own information and it's just constantly being asked of them, why haven't they got IT systems in place that just spit that all out at the press of a button? How is it that instead of fixing those systems, do we have a government proposing to radically reduce the right to know through FOI? I mean, those two agencies just prove the point, don't they?
Yeah, I absolutely agree. I tend to think they do. And I guess in a digital world too, where most documents are digital in some form, it's hard to understand why it's become so difficult and inefficient, and why it's so difficult to create a system that allows for faster, more efficient retrieval.
Yeah. I know that we're hearing about the particular impact of freelance journalists, what the costs are likely to do. But could you give just a realistic impact of what it would mean if you added substantial additional costs to FOI, what we would lose, what we're likely to lose if this bill becomes law and there's that additional cost barrier?
Senator, can I just very quickly jump in here? Just to, I'm not going to be very long with this, but one of the things that I think the Attorney General indicated when she introduced the bill was that the idea of costs was less about recovery of the costs of processing the applications than it was about discouraging frivolous and vexatious applications. And we understand and recognise that that is a problem, but we disagree that that introducing costs is the way to do it. There are much better ways of managing that through all sorts of digital processes that can filter out those kinds of vexatious complaints, or vexatious applications rather. The fact is that, as we've already heard from my colleagues at MIA, the introduction of fees is going to effectively ruin the ability of journalists to do their jobs. And while we understand that for individuals who may be seeking personal information as a one-off, that may be appropriate, it may be acceptable. But as my colleague Daniel Moon said, we need to be treating this as a cost of doing democracy, not as a way of recovering the cost for government.
We heard some pretty tenuous evidence from Home Affairs that one of the reasons they want to clamp down on FOI was because unnamed nefarious foreign actors will be using FOI as part of a mosaic of other information gathering. Now, I don't know what the other information gathering is. Maybe it's reading newspapers, blogs, Twitter, but somehow that if we take FOI away from foreign agents, they won't be able to create this mosaic of information about Australia from other readily available sources. How much weight do you think we should give to that kind of national security concern? Professor Crest?
Sorry. I just look. The idea of the mosaic effect, I'm sure in intelligence circles is real, but we don't see that being a problem in any other jurisdiction that has more open, transparent, and accessible freedom of information systems. And I find it hard to see that ours should be any different.
Well, if you take that to extremes, you shut down the ABC.
Yes,
you close social media. The mosaic argument can go in any direction, and they've just pointed at FOI here.
And the mosaic argument means that you shut down information, period. I mean, that's the logical consequence of that argument, and we don't accept that.
Yeah, I think there have been a number of people asking, is this bill salvageable? The broad thrust we've had from submissions to this point is, if you want to fix FOI, you wouldn't start from here. Just briefly, in the views of any of the witnesses, is this bill salvageable?
We don't think so. We think it should be scrapped and we should start again from scratch. We don't see there's any value in talking about amendments to the existing bill. We'd rather see it start again. Yeah.
If anyone thinks differently, please speak now.
No, Senator, we not only think that we need to start again, the starting point has to be more disclosure, not less. That's got to be kind of grounded in that process.
All right. Thanks, Chair.
Thank you. Thank you, Senator Shoup, and thank you to all of our witnesses for your evidence this afternoon. If you've been asked to provide any additional information, would you please forward it to the Secretary by the 24th of October? And you'll be sent a copy of the transcript of your evidence, and we'll have an opportunity to request any corrections to transcription errors. Thank you very much.
Thank you, Senators.
Thank you.
Thank you, everyone.
While everyone is taking their seats, I'll take the moment to welcome representatives from the Office of the Australian Information Commissioner. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. I remind senators and witnesses that Senate has resolved that an officer of a department or of the Commonwealth or a state shall not be asked to give opinion on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only asking questions for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about how and when policies were adopted. For the Hansard record, would you please state your full name and the capacity in which you appeared before the committee today?
Thank you, Chair. Elizabeth Tidd, Australian Information Commissioner.
Thank you, Chair. Alice Lineker, FOI Commissioner.
Thank you. And do you have an opening statement?
Thank you, Chair, if I might. Good afternoon, Chair.
Absolutely.
And committee members. I appreciate the opportunity to make some brief remarks on behalf of my colleagues, including our newly appointed Freedom of Information Commissioner, Commissioner Alice Lineker, in relation to the FOI Amendment Bill. As the regulator, the OIC has a unique contribution to make to FOI reform. However, we are also respectful that our insights reflect our context and not that of all of the voices that can contribute to this important process. Our role is to effectively operationalise the legislation passed by the Parliament. I also take this opportunity to clarify paragraph 90 of our submission and reflect that since my appointment in August 24, I have not sought additional funding in respect of FOI through the regular budgetary process. Additionally, we've taken decisions to better manage our FOI functions through internal allocation of staff and budgetary resources aligned to functions. These factors, together with the process improvements implemented and enacted by FOI commissioners under the reinstatement of the 3-commissioner model, have delivered OIC productivity increases, notwithstanding the rising volume of applications. The average age of an IC review has declined to just under 12 months. In 2024-25, we finalised 41% more IC reviews than in 2023-24, notwithstanding a 21% increase in applications that same year. Against these gains, the OIC welcomes the committee's consideration of the bill as it provides an opportunity for a public debate on ways to improve and modernise the operation of the scheme. This welcome examination is contextual. The statute enshrining Australia's adoption of Article 19 of the UN International Covenant on Civil and Political Rights is one aspect of this scheme that supports democracy and integrity. The effectiveness of the information access regime requires consideration of temporal, operational and cultural factors. The bill provides a number of reform measures to inform the legislative aspect of this complex system. As such, each measure should be considered against the totality of the proposed and extant provisions to better appreciate the collective impact in the regime that enlivens this right and ultimately properly balance factors in favour of and factors against disclosure of information. We are operating within the digital age, and our adoption of technology is generating an unprecedented volume of information. This creates challenges for agencies in managing information, including the practical aspects of requests for information from a community conversant with immediate access to information. Technology can also provide solutions to these challenges, practices to promote proactive release of information through public-facing data repositories, automated systems to support release of public information, centralised record systems, citizen access portals for centralised lodgement of applications, tools for discovery and redaction, and webbed case management systems to support agencies all offer opportunities to improve the operation of the information access system. FOI applications made to agencies and ministers increased by 8,750 in 2024-25, or 25%. If one agency, Home Affairs, is removed, the overall increase decreases to a 9% increase. Our practitioner survey tells us that only 26% of agencies have a case management system in place, and 63% manage FOI applications using spreadsheets, including Excel. Whilst the number of FOI applications rose significantly, agencies reported that the time spent on each application decreased in 2024-25 from 4.2 days to 3.6 days. Costs, however, increased by 14%, driven by higher legal advice expenditure, a 43% increase, and litigation costs, a 10% increase. Operationally, the system is increasingly under pressure, demonstrated by the number of decisions that are not made within the statutory timeframe increasing. This situation has a direct impact on review rights. A failure to make a decision within time extinguishes an individual's right to internal review and results in an increase in the number of IC reviews arising from deemed decisions. In 2020-21, deemed decisions represented 39% of our caseload, and in 24-25, the percentage increased to 79%. These applications are required to be case managed by the OIC to support decision-making by the agency. The bill, as drafted, seeks to inject certainty into review rights, and this may provide greater operational clarity and certainty for access seekers, together with efficiencies for the system. Proposed amendments to Section 54W will give my office a discretionary power not to undertake an IC review where there is an ongoing internal review application of an access refusal or access grant decision, and the agency has not yet made a decision. The outcomes of IC reviews also provide significant insights into the operation of this aspect of the system. In 2023, 24 and 24-25, 70% of agency decisions were varied or set aside on review. As the regulator, the OIC has recognised and committed to contributing to the uplift of APS decision-making capabilities through practitioner engagement and education. Our program is delivering results and insights, with 82% of practitioners advising that they regularly utilise our statutory guidelines as the most used resource. A pro-disclosure culture and APS capability uplift will also improve the overall operation of the Access to Information Framework. Digital communication has also introduced cultural challenges, with agencies reporting concerns regarding hostile communication that present risks to staff wellbeing. This places an additional pressure on the system. The OIC has received 59 applications to declare an applicant vexatious since 2011, with 6 applications currently on hand. In the context of 74% of applications seeking personal information, decision-making is well supported by a system that requires the identification of the individual or their representative. The FOI framework provides a more certain and comprehensive access framework supported by more cost-effective review pathways than other statutory regimes, such as those under the Privacy Act. Similarly, the positive communication and assistance that should characterise requests for government-held information may well be aided by trusting exchanges unencumbered by the use of pseudonyms or anonymity. This proposed reform offers benefits. Balancing the need to protect the identity of whistleblowers can be achieved through deployment of technological systems in use in other jurisdictions that, like the OIC, actively contribute to the Commonwealth Integrity Framework. Complaints regarding delays by agencies comprise approximately 35% of complaints to the OIC regarding FOI applications. Increasingly, the OIC is applying data to inform proactive and systemic regulatory action. The early results of this approach are pleasing, with the majority of agencies accepting our recommendations. However, 66% of complaints to the OIC do not progress to investigation. A number of these, on our assessment, lack merit. The proposed amendment to Section 73 of the Act to provide additional grounds on which the delegates can decide not to investigate a complaint should enhance our overall effectiveness. This amendment also aligns with the statutory outcomes available under the privacy regime. Improving access to government-held information and managing it for a public purpose to realise its value as a driver of integrity, trust, inclusion and innovation is a multifaceted task that should be broad-ranging, balanced and responsive to our contemporary operational and cultural environment. Thank you, Chair.
Thank you very much for that detailed opening statement, Commissioner. We will now proceed to questions and go to Senator Collins.
Thank you, Chair. Thank you, Commissioner, for your opening statement. I'd just like to ask, when the Commission was last before estimates, you revealed that your full-time equivalent went from 175 as at 18 December 2024 down to 138.4 on the 29th of January. Do you know what your FTE is today?
Thank you, Senator. Our allocation through the budgetary process of ASL is at 176 staff, and we currently have around about 160 plus filled positions. So we're still recruiting to some positions.
So 160 of those 176 have been filled?
Correct. Thank you, Senator.
In answer to a question on notice, you confirmed that your structure had dropped from around 200 FTE in July last year to 136 by February 2025. Do you acknowledge that that's a massive cut to your resourcing and capability?
Senator, the OIC, like all agencies, has baseline funding and funding that is temporarily limited. And some of the funding that we were provided, including the staffing quotients associated with that funding, terminated for reasons including that the funding was provided for standing up new schemes, and those terminating measures have been managed through our new structure and the restructure of the OIC to that ASL of 176. And we now have a structure that enables us to work more relevantly to functions than to discrete statutory regimes.
So you're saying that, just so I can understand clearly, you had new schemes and so the funding had to go from the staffing to the schemes. Is that what you were saying?
No, I'm sorry, Senator. If I could clarify, some of the funding was terminating funding, and it was always identified as terminating funding. We had some new funding introduced in the MyEFO, and we have an operational staffing level of 176 now. Organisationally, so within the structure of the ISC, we're applying staff, particularly in the case management area, which is the focus of this FOI, case management and our review function. We have drawn on staff capability in relation to both statutory regimes that offer review of complaints, for example. So we're using our staff to optimal levels and training our staff to ensure that they are able to operate in those jurisdictions.
Yeah, so just focusing particularly on the full-time staff allocated to freedom of information, I understand that between July 24 and February 25, the number of staff allocated to FOI case management had dropped to 22.74 from 33.05. So it's about a third of your staff had been dropped. Is that correct? Does that sound right to you?
Senator, discrete allocation to aspects of case management, so aspects of FOI case management, is in part only undertaken by officers within FOI, but there are other aspects, for example, the early triage and assessment of applications and complaints is undertaken by officers who support both FOI and privacy case management. So it is not correct to say that we only have 22 staff in FOI. We have definitely ensured that our case management operates against the functions and that we have numbers exceeding 22 in that entire case management area. We've also undertaken a structure that enables us to better inform guidance, for example, which was a discrete FOI function previously, into a whole of OISC approach where we leverage the guidance provided both within FOI and privacy in another area of the OISC and feed data into that to inform the sort of guidance we're providing to agencies to ensure that it's responsive to their needs and the community's needs.
So you're saying that your staff were taking up essentially two different responsibilities. Were you doubling the workload of the staff that you had to pick up the slack of where you lost the staff?
Senator, the short answer to that is no. We're training our staff to undertake the assessment, say the early assessment of a matter coming into the ISC in relation to both statutory streams and ensuring that they are adequately resourced with training and systems to assist in that regard. We could always do better with our systems, like my opening statement in relation to agency systems, and IT uplift is something that is definitely at the forefront of our agenda.
Sure.
Thank you.
But did it end up slowing the process down because, you know, you're having to not double the workload but essentially do the same job in the same amount of hours? So did you find that the cases were slowing down?
Thank you, Senator. I'd be delighted to take a response to that question. Last year, in 24-25, we received 21% more applications just in the FOI area, and we finalised 41% more. The year before that, when our process improvements started, we had a 7% increase in FOI applications for review, and our finalisation rate increased by 15%. The staff have done a remarkable job both in FOI, and privacy is also starting to show the same sorts of results. Our case management techniques have had the benefit of the 3-commissioner model, where FOI commissioners in particular have worked very closely with their staff and, of course, our privacy commissioner to ensure that they have the processes and clarity of process to deliver these remarkable results.
Thank you. And I know I'm very short on time here, but...
Final question, Senator.
Thank you. Yep, I'll finish it on this. But you said a huge amount more finalised, but how much of that are FOI cases that are rejected?
Senator, and this is an approximate.
And what's the trend in that at the time?
So the trend has increased in our number of actual determinations under FOI, so 55K decisions. The written decisions that we publish have increased over the last 3 years considerably. Approximately 200 written cases were provided in 2023-24 and about 248-50 and 24-25. So the outputs in terms of substantive outputs requiring a well-reasoned decision have increased as well.
Thank you.
Thank you. Senator Pocock.
Thank you, Chair. Thank you for your time here this afternoon. The 2023 Senate inquiry into the operation of FOI, which was sort of stood up after Robodebt, references the fact that OAIC received $1 million to do a strategic assessment in 23-24. It's referenced on page 25 and then throughout the report. The assessment is referred to in the 2023-24 OAIC corporate plan, but then never referenced again. It's not in your submission nor the AGD's submission. I'm wondering if that assessment was completed.
I think, Senator Pocock, if I might take the moment to clarify, are you referring to the strategic review of the OIC?
Yes, the strategic assessment 2023-24.
Yeah. That review has been considered by the OIC. It made a number of recommendations around our regulatory posture, our risk base in relation to our posture, focusing more on both education and enforcement. We've implemented those. It also made recommendations in relation to our governance structure, which go to the 3-commissioner model, which I have the absolute benefit of working with 2 extremely talented commissioners. And so our governance takes a whole of OIC approach rather than a segmented approach. The other significant issue is that through that process, there was a recommendation that we undertake a restructure of the organisation to better fit the 3-commissioner model, and we have done that. Sure. And I think the results I've outlined are demonstrating the success.
Are you able to just table that report for us?
That is a matter for government, to the best of my knowledge. Senator Pocock, in terms of there have been, to my knowledge, requests for FOI for access to that report, and a large part of it has been released. To the best of my knowledge, it's on our disclosure log. Other aspects may not have been released.
When was that provided to government?
The report provided to government, to the best of my knowledge, it was early in 2024.
Okay. Maybe I'll notice the exact date,
Thank
please.
you.
And why has it not been released publicly?
It has been released on our disclosure log through FOI requests.
Yeah,
that's
but
correct.
why hasn't it been proactively released to the public?
The report was commissioned, as I understand it, through government, through a government steering committee that involved a couple of government agencies. So that decision would not have been mine or that of my predecessor. It would have been a matter for those government agencies.
And under the FOI determination, why wasn't the whole assessment, whole report released?
I couldn't take you to the precise decision
Maybe just on
itself.
notice then.
There would be aspects of the report that, through an FOI process, determination was made not to release aspects of that report.
Were you consulted in the drafting of this bill that we're looking into today?
There are largely 4 phases of consultation. As a regulator, we have a responsibility to regularly inform government about regulatory aspects, operational aspects of the statutes that might be able to be improved. So that's ongoing. I'd say that's stage 1.
Could I maybe just go to I'm interested when the government first consulted you and what form that took?
We were consulted throughout July and August on discrete aspects
this year?
Correct, Senator.
Which aspects of the bill?
Various provisions of the bill. We saw the bill in totality on the 30th of August. 30th
of August. In July, what were
Senator,
the parts of the bill that you were asked about?
Sorry, if I might just add that there have been, as my colleague mentioned, there have been ongoing conversations with the department about aspects of regulatory performance that the OAIC or provisions in the bill that we think could be adjusted or amended. So although we may have been formally consulted about this bill in June or July, many of these items in the bill that go to particular issues for us. So things like not having concurrent IC reviews and internal reviews are things that we have asked for and that we think will improve the efficiency of the system.
Mm-hmm. Well, I mean, given you're in charge of FOI, which provisions were you consulted with in July?
Senator, I could not tell you which provisions. It was a matter of us being provided with provisions and responding to those provisions. And as my colleague says, some of those provisions did actually reflect the issues that we had identified in phase 1 consultation with the department.
Why can't you tell me the provisions?
Off the top of my, I think there are about 31 changes, Senator, so off the top of my head I would not want to...
Maybe just on notice which provisions were consulted on in July. At page 8 and 9 of your submission, you talk about the bill creating what you describe as, and to quote, 2 systems of FOI law operating at a federal level. And then you go on to say that the dual system would have, and to quote, an operational burden and increases the cost of compliance and access for participants in the FOI framework. Would this create a bit of an administrative mess to have these two frameworks?
As proposed, Senator.
Thanks, Senator Pocock. That was your final question, and I'll need to rotate the call. Sorry, Commissioner.
You can still answer.
Yeah, sorry, I should have been clearer. That was the last question from Senator Pocock, but absolutely you can continue to answer.
Thank you, Chair. Operating a dual system when legislative change takes place does mean that, for example, in relation to our statutory guidance, we would have one set of statutory guidance that operates in relation to the applications made before the passage of the enactment of the legislation, and arguably, in part, different systems operating that are explained through statutory guidelines for those amendments that then come into effect, that then apply to applications made under that regime from the time that the system changed. That's just one aspect of the changes that would be in place. As a regulator, it is up to us to ensure that the community and agencies have the education and guidance that they need to be able to operate, and that operation would be for a period of time in 2 systems.
Thank you. Thanks, Chair.
Thank you, Senator Pocock. Senator Shoebridge.
Thanks, Chair, and thanks, Commissioner, for your submission, your helpful submission and your evidence. Can we just go back to one of the reasons, perhaps, why there's so much time being spent by bureaucrats in doing FOI requests? Did you say that only just over a quarter of agencies have proper document management systems? Was that your evidence, 26%?
Senator Shoebridge, I'm grateful for the opportunity to clarify. That's in relation to an FOI request. So a case management system in an FOI request might allow you to properly manage that application, auto-generate standard receipt correspondence, for example. So you're correct in saying my evidence was, I think, 26% of agencies have those specific case management systems. About 63%, 64% operate on things like an Excel spreadsheet, for example.
All right. And then the rest of them, what? They just make it up as they go?
I think that's almost the totality of the 100%, if my maths is correct, Senator Shoebridge.
Right. So isn't there a sort of guidance for best practice or a standard tool available to the public service which says, well, actually, you know, this works, we use it in X agency, and I'm astounded that there's not some kind of standard tool available for agencies to do FOI requests. Has it ever been explained to you why there isn't?
I couldn't fully answer that question, Senator Shoebridge, because there's no system prescribed, and each agency operates with different document management systems, other case management systems, different infrastructure.
But Commissioner, if some of them are running off an Excel spreadsheet or a Google Doc to handle all their FOI requests, and some have actually properly developed case management tools that make it vastly quicker, more efficient and more accurate, has it ever been explained to you why that's the case?
Senator, I have not engaged in discussions across the sector to understand that. My visibility would be that each agency does deploy different IT systems and very different interfaces. I think the agencies that do have the opportunity of a case management system would have the advantage of better technology to support them.
Yeah, but why hasn't that been uniform? It's as you've brought heads of agencies together and spoken with them, you've never asked them, why don't you just get the case management tool from X agency? Why don't you get it tomorrow? These conversations never happen because, I don't know, if they don't happen, why don't they happen?
Senator, we do regularly share best practice examples, and you will see that in our annual reports. We also share best practice examples through things like our guidelines, together with our FOI webinars. We also have now developed this year 2 other tools to really assist agencies. One is a time calculator developed within the OIC so that agencies can actually calculate the periods of time so that they are aware of when a deemed refusal might occur.
Commissioner, just stopping you there. The worst outcome from the public's perspective is you get an agency that's running off a Google Doc with a grossly inefficient process for accessing documents, and then they get a time assessment tool from the OIC, and then they say, oh, it's taking me 200 hours to process a standard request, and then they're billing the public for it or using it as a reason to refuse applications. Surely the focus should be on getting best practice uniformly adopted rather than adopted by a tiny minority of agencies.
Senator, you're correct to identify that things like portals for lodgement and management of applications that are centralised are developments occurring internationally. If I could also clarify in terms of the support the OIC is giving in this regard, the time calculator is to look at the days between lodgement and finalisation, for example, not the time spent. Also, we have rolled out this year a tool which is an agency self-assessment tool for them to determine what infrastructure they require to best meet their demands. We are really focused on, and you'll see in our commitments, making compliance easier so that we are able to work with agencies more effectively.
Commissioner, I'm not blaming you for this. I mean, this is obviously a responsibility of agencies like the Public Service Commission, various ministers, some kind of centralised response. But it does seem to me astounding. We're at 3:30 in the afternoon on this inquiry, and we find out at 3:30 that barely a quarter of government agencies actually have a case management system for handling FOI requests. Like, it just seems to me so fundamental to good government in this space. I mean, am I wrong, or is this fundamental to good case management, good FOI handling, to have a case management system?
Injecting certainty and clarity in the process through technology is absolutely welcome and a great contributor to an effective system. I would also add, though, Senator, that the landscape of agencies dealing with FOI is vastly different. It varies greatly from mega agencies through to small independent agencies, and that variety might also be one of the factors impacting the use of a standard system.
But we're talking about a case management system that can just be replicated from agency A to agency B. It's some computer software that can just be handed over. That's really no institutional barrier, is it?
Thanks, Senator Shoebridge. We'll consider that your final question and the Commissioner can answer that.
Senator, I can't with certainty offer insights into the IT systems of every agency or agencies more collectively, but I can say that technology does assist in processing, in redacting, in managing FOI.
Where it's used.
Thank you, Commissioner. Thank you, Senator Shoebridge. Senator Nandaraja.
Thank you, Commissioner. Can you hear me all right?
Thank you.
I'd like to just go over some numbers just quickly because I do want to draw you out on the regulatory changes that were introduced in 22 and the impact of AI. So I'd like you to just tell the committee How many FOI requests have been received across the system in 24-25?
It's approximately 43,000, which is an increase of 25%, Senator. We can give you the precise figure in just a moment, but it is around 43,000 applications.
43,456, Senator.
Thank you very much. And is this the highest number ever on record?
That's correct, Senator.
So claims that deny an increase are not right then, are not correct. There have been some claims that suggest that this number has not increased. Those claims would be incorrect then.
Senator, I haven't heard those claims, and we have published data. Agencies provide us with data, and we provide quarterly updates on a dashboard. And to the best of my knowledge, this is the highest recorded number of FOI applications.
And how much time in hours did public servants spend in 24-25 processing these requests?
Senator, if you just give me a moment, I can tell you that I think in accordance with my opening statement that overall agencies reported to us that they spent about 3.2 days per FOI application.
And cumulatively? Have you got a cumulative number?
No, I'm just looking to my colleague.
I don't think we'd have to take a cumulative number on notice. I think that we assess it based on hours per application.
Okay, thank you. 3.2 days per FOI application.
Yes.
Yeah. And what was the cost to taxpayers in 24-25 to process all these requests, given that it was a record number?
It was approximately, or very close to, $1 million, and that derives from a base where there was an increase in the cost of FOI reported by agencies of 14%. The volume increase was 25%. Those costs, I think I outlined in my opening statement, were largely driven by the legal expenditure costs.
Understood.
Sorry, Senator, okay. I think, just to correct it, I think I misspoke. It's 3.6 days, not 3.2 days.
Okay, so it's closer to 4 days per FOI request. All right, thank you very much for clarifying that. I just want to move on to the regulatory changes that came in 2022. I understand that these changes meant that the AOIC communicated to agencies that an FOI request could be granted in part if irrelevant matter was deleted in accordance with the Act. Is that correct?
Senator, I don't have that before me. As I understand it, your question's going to the issue of release in full, release in part, and there was a variation applied in that regard. The constant has been refused. So a refusal has been reported consistently, and that maintains a baseline for statistics for examination by the regulator and through examination like the one we're currently involved in.
Understood. And can I just go back to the cost? Could you just clarify? You said that 3.6 days per FOI request, 43,000 a year only amounted to $1 million. Is that correct? Does that make sense? $1 million seems undercooked to me.
If we could take the precise figure on notice or come back to that question, please. We rely on the data reported to us by agencies, and I think my colleague might have that data available to her now.
The total cost reported by agencies was $97.99 million in the 24-25, and that was an increase, 14% increase on 23-24.
I see. So it's in fact close to approximately 4 days per FOI request, and the cost is closer to $100 million.
That's
so
correct.
It's sitting at closer to $98 million.
That's correct, Senator. I apologise for misspeaking in that regard.
Okay, no, thank you, Commissioner. Thank you for clarifying that. And just going back to the regulatory changes in 2022, can you just talk us through the issue of granted in part and granted in full or refused? Can you just perhaps elaborate what that means for the committee's benefit, please?
Thank you, Senator. There are a couple of indicators that apply really internationally in relation to the operation of the FOI system, particularly for first instance decision making, and they are within the statutory timeframe. They are the issue of what's varied or set aside on review by an independent commissioner, and they are the refusal in full. And the refusal in full is, if you like, one outcome that has a relationship to the granted in full and in part. So within the context of 2024-25, the refusal rate was 25%. I think you're referring, Senator, to an amendment whereby the OISC offered guidance to agencies in relation to the redactions that they might make. So instead of it being recorded as a released in full, it did reflect with some redactions that it's released in part.
I see, okay. And in your annual report, I understand that you expected fewer FOI decisions to be recorded as granted in full and more to be granted in part following this change. Was that right?
I think that would be correct, thank you, Senator, because of the fact that a redaction from a document is a release in part.
So any reduction in the terminology granted in full it's actually not entirely an accurate reflection of the processing that has gone on in the back end, because it may be that in fact what was happening is that in your own report you say little could be read into this decline because it is the result of a change in reporting rather than an underlying change in the way FOI requests are decided.
And Senator, if I'm understanding the question correctly, we're saying that little can be read into it because of the fact that the totality of release is measured by release in full and release in part. The constant is the refusal rate.
Right. Can you just sort of go back across that again, please? Because the way these were reported has had an impact now on how these are actually portrayed to the general public, right? So
Senator, I think I'd agree with your assessment, and the annual report recorded that you couldn't read much in because once it's Section 22 deletions, then although the document has deletions in it, it meets the full extent of the request from the applicant. So I agree with your the assertion within your question.
I just want to move on, thank you. I just want to move on to the role of the impact, I should say, of artificial intelligence. Do you have any concerns with regards to the rise of AI and our current system?
Senator, thank you for that question. I'd like to answer it in relation to three categories of information that go to the issue of anonymous applications. So identification of the applicant, as we've set out in our submission, would assist in determining applications for personal information because clearly the identity of the application is important. So too in relation to the efficiencies that flow from that. So better decision making would arise in that regard. In relation to the issue of whistleblowers, for example, there are technologies that are used by other integrity agencies to preserve anonymity. In relation to AI, two dimensions I'd call out. One would be AI being used to assist in the formulation of an FOI request as distinct from generated agenic requests that might involve a bot, for example. So we in our guidelines have tried to assist agencies with a very recent update to really help agencies in addressing what is potentially a new threat, and we have specified that applications can only be made by a person. There are technologies that assist agencies in this regard, like capture, and they're in use in some agencies within the Commonwealth.
Understood, but they're not 100% perfect. There's if there is a campaign, or if anyone wanted to generate AI-generated requests for freedom of information, there wouldn't be a 100% foolproof way of detecting that at the moment.
Senator, the AI...
Because these are anonymous. These can be anonymous requests, right? There's no provision right now for people to identify themselves. So it could be these could be bot-generated requests.
So, Senator, I can't speak to the capability of IT in that regard, but I think our submission does recognise that in identifying a person, particularly when 74% of applications are for personal information, there would be efficiencies associated with that. And likewise, in respect of the authority of someone to represent an individual would ease some decision-making in that regard and take out some additional administrative aspects that agencies face in identifying the application.
Senator, if I... Thank you very much. Sorry, okay. Senator.
Thank you.
Sorry, did you want to finish? Did you want to add to that?
I just wanted to note that on the 1st of October, the OSA released updated guidelines under Part 3 guidelines that talks about particular methods that agencies might consider of addressing bot-generated requests, noting that they're not made by people, and so there is a task for agencies to consider. I think that anything that makes that task easier would be welcome in terms of the regulatory certainty of the scheme, and so I just refer you to our recently updated guidelines.
Well, just one last question. Senator Stewart, just one last follow-up question. What would make this easier would be a web form with people identifying themselves, with identifiers in it.
Yes, Senator.
That would circumvent all of this, correct?
We certainly think that ensuring that applicants for information are required to identify themselves would make things easier in terms of identifying whether or not they are a person for the purposes of Section 15 of the FOI Act.
Thank you.
Thank you very much. And thank you for taking the time to give evidence to the committee today. If you've been asked to provide any additional information, would you please forward it to the Secretary by the 24th of October? You'll be sent a copy of the transcript of your evidence, and we'll have an opportunity to request any corrections to transcription errors. Thank you very much.
Thank you, Chair. Thank you, Committee.
Thank you.
And as we have our next witnesses making their way to the table, I'll get started on the statement. So I now welcome representatives from the Attorney-General's Department. Thank you for taking the time to speak to the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. I remind senators and witnesses that the Senate has resolved that an officer of the Department, officers of a Department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about how and when policies were adopted. For the Hansard record, will you please state your full name and the capacity in which you appear before the committee today?
Thanks, Chair. Celeste Moran, First Assistant Secretary, Attorney-General's Department.
Dior, Assistant Secretary, Information Law Branch, Attorney-General's Department.
Jane McClintock, Director in the Information Law Branch.
Thank you very much. Is there an opening statement that you'd like to make?
Chair, I've got something quite short, so I'll go as quickly as I can for you.
Please.
We'd like to thank you for the opportunity to appear today. Our evidence today supplements the department's submission, which sets out information about the FOI system, data that informs how the system is operating, the rationale for reform, and an overview of the FOI bill. As we've just heard in the previous session, agencies received 43,456 requests in 24-25, which is a 25% increase on the year prior, finalised 39,390 requests and made 21,211 decisions. 74% of decisions were made within the statutory timeframe. The cost of the FOI system has been steadily increasing over time. In 24-25, FOI processing was estimated to cost agencies $97.99 million, a 14% increase on 23-24, which was $86.24 million. The bill recognises that there has been significant changes in the operating environment since the FOI Act commenced in 1982, which commenced in a paper-based environment. Technology, including the use of email, the internet, web forms and the rise of AI, is changing the way requests can be made. The volume of electronic documents created and stored is increasing rapidly each year. By way of example, in the Attorney-General's Department alone, between April 2024 and April 2025, over 1.1 million electronic records were created in its content management system. The Department of Home Affairs submission notes that the average number of pages assessed is 175 pages per request. There are also issues with applicant conduct, which are presenting work, health and safety issues for APS officers and can interfere with the capacity of agencies to respond to requests made in accordance with the objects of the Act in a timely manner. The bill contains a range of measures to update the Act to reflect the modern environment and make the system more efficient. Of note, the bill requires an applicant to provide a name when making an application and sets out the circumstances in which an agency or minister can require proof of identity. These amendments serve a number of policy imperatives. Provision of a name and a requirement to provide identity information would assist to ensure that personal or private information is only disclosed in appropriate circumstances, such as to an individual who is seeking their own personal information, by codifying in legislation the current expectations for agencies and ministers to confirm identity in order for such a request to be processed. Provision of a name and a requirement to provide identity if requested would also ensure vexatious application declarations are effective and unable to be circumvented via the use of a pseudonym or an anonymous request. Protect the safety and wellbeing of agency officers by discouraging applicants from engaging in inappropriate or threatening behaviour when making a request, and enable agencies to know who they are dealing with, which may go some way to deterring inappropriate use of AI or by foreign actors. The Department does note that other Australian and international access frameworks similarly require provision of a name, including in New South Wales, Tasmania, the Northern Territory and the UK. The Department is happy to take the committee's questions. Thanks, Chair.
Thank you very much for that opening statement. We'll proceed to questions and go to Senator Collins.
Thank you, Chair. And thank you so much for your testimony just now. In her second reading speech on this bill, the Attorney-General said, the ability for freedom of information requests to be lodged anonymously also risks undermining the integrity of the framework, and in combination with new technology creates risk factors that could be exploited by offshore actors seeking government-held information for potentially nefarious purposes. Were those words in the second reading speech drafted by departmental officials?
Senator, I'll have to take that on notice to be sure. We, of course, had a role in the development of the second reading speech, but as to the exact content, I would have to take that on notice.
So you would be aware then of what the nefarious purposes to which the Attorney-General was referring, what was meant by that?
Well, Senator, in the development of this bill, the department did engage with the national intelligence community and did seek advice from them in relation to the issues that you've raised. And we were provided some advice in relation to that, which in broad terms, and I think the Department of Home Affairs provided some advice on this earlier today, is that it is not uncommon for foreign actors to seek to use legitimate government processes to gather information and to put that together to paint a particular picture and use it against the national interest of Australia.
Okay, so there was advice given, but do you have any evidence to establish the link?
Senator, the information provided is of a classified nature, and so I'm obviously limited in what I can say, but what I've just said to you is what the National Intelligence Committee was comfortable with us saying in this forum.
So are you able to give us the numbers of FOI requests that have been rejected on the grounds that they were linked to offshore actors or for nefarious purposes or anything of that nature?
Well, Senator, I don't have that information in front of me, and it's not something that I think is reported through to the OAIC in terms of the yearly reporting that they do.
Okay, so then there's no evidence that you have that this is actually happening then?
Well, Senator, what I said earlier in my evidence was that we did consult with the National Intelligence Community about these issues. They did provide us some advice, and I've outlined for you what I'm able to say and what they're comfortable with me saying in relation to those issues in this forum.
Understood. So my understanding of that then is that the National Intelligence Community has oversight of the FOI requests then?
Well, Senator, they have information in relation to the kind of intelligence system more generally. I know that more specifically the Department of Home Affairs submission to the 23 Senate Legal and Constitutional Affairs inquiry into the FOI system did address the risks of foreign actors in the system, which is also in the public domain.
Okay. Do you know how many FOI requests are known to be linked to criminal gangs?
No, Senator, I don't.
Are you able to take that on notice?
Sure, happy to take it on notice and see if there's any information we are able to provide.
Okay, thank you. And if information is released under FOI in response to a legitimate FOI request, what options are available to the department to ensure that information is not passed on to a hostile foreign power or criminal gang? Sorry, Senator, could you repeat the question for me, please? So if you've got a legitimate FOI request, how can you ensure that the information is not passed on to a hostile foreign power or criminal gang? What processes are in place basically to screen that? Well, Senator, I think there are a range of exemptions under the Act currently that agencies can take into account in deciding essentially the harm of release of those documents, and one of those is on national security grounds. But more broadly, each agency makes a decision on each FOI request and assess whether or not the information can be released or whether the information falls within one of those exemptions. And ordinarily, and in most cases, information is therefore provided to the applicant and then made available on the disclosure log. There are some limited exceptions where information is provided to applicants that is then not put on the disclosure log, but ordinarily those decisions are taken at the time the assessment is being made as to harm as to the release of that information. Okay, thank you. Is the department aware of any specific instances where it has been alleged that the prospect of receiving an FOI request has resulted in a departmental official not complying with their statutory obligation to provide frank, honest and evidence-based advice to the government, free from political influence?
No, I'm not aware of any specific instance, but I think the committee's heard evidence earlier in the day around the reviews, the Thodey review and the Shergold review, which talked about issues around public servants providing frank and fearless advice following the 2010 reforms. And I think further evidence has been given by the Public Service Commissioner on this matter through the estimates hearings process.
Okay, thank you. Just following on from that, though, does the department censor the advice it provides government because of FOI?
No, Senator.
Thank you. Is the department aware of any specific instances where the prospect of receiving an FOI request has resulted in a departmental official not complying with their statutory obligation to provide frank, honest and evidence advice? Oh, I'm sorry, that's the same. I think that's the same one. No, that's different. Is the department aware of any specific instances where the prospect of receiving an FOI request has resulted in a departmental official not complying with their statutory obligation to provide frank, honest and evidence-based advice to the government?
No, Senator.
I'm not aware.
Final question,
Okay.
Collins.
Thank you, Chair. This bill allows the department to refuse to deal with a vexatious application, as you were mentioning before, as opposed to a vexatious applicant, effectively meaning that you don't need to remove anonymity to refuse to deal with an improper and vexatious application. So my question is, why remove anonymity and impose that barrier, which may, among other things, expose applicants to retribution and other adverse consequences?
I think we've covered that in our opening statement, that the requirement of a name and identity information is serving a range of different policy purposes, including in protecting the release of personal information for those types of requests, which form the majority of requests made under the FOI framework, in addition to making the vexatious declaration power that the Information Commissioner exercises more effective.
Sure. Sorry, just in the interest of time, I'd adjust the question then. Would you agree that, people who are submitting under anonymous conditions are doing so to protect themselves as well? That perhaps, requesting that FOI may have adverse consequences on themselves if they had identified themselves.
I'm not sure what adverse consequences you're referring to.
Well, there would be some circumstances in which they would want to protect their identity when asking for specific information on certain topics.
Senator, I think what we'd say is that, of course, currently under the FOI legislation, you are allowed to be anonymous. But what we've tried to do in the opening statement, and that Ms Orr has tried to outline, is that there's a balancing exercise, and what the government's position is that there are a range of policy imperatives that have led to a decision being taken, which is outlined in the bill, to say that on balance, anonymous requests shouldn't be allowed under the FOI Act.
Thank you, Senator Collins. Senator Shoebridge.
Oh, thanks, Chair, and thanks to all the officials for your attendance today. Ms Morgan, to you or whoever is best able to answer, I do note that some documents have been produced under FOI, and I think I may have not given you credit for the department producing some documents to my office under FOI, so I apologise for that earlier in the day. But in having gone through some of those documents, one of them is an email, I think, sent from you to some of the team about the consultation with security agencies about this foreign adversaries point. Are you familiar with that document?
Yes, Senator, in broad terms.
Yeah. What it appears to show is that the security agencies didn't come to you with this concern, that you actively went out to the security agencies and sought that advice from them. Is that, am I misreading that document?
Well, we certainly did seek advice from the National Intelligence Community, Senator. That's correct.
Yeah, so it wasn't as though you had national security agencies out there saying, oh my God, we have to deal with FOI, otherwise, Myanmar is going to tear down our government. This was you reaching out to the agencies and saying, what do you think might be some national security implications for FOI?
Well, Senator,
is that right?
I'm not privy to, on a day-to-day basis, the work that we do doesn't formally intersect with the national security side of what government does, but so I'm not privy to all of the discussions that happen in relation to that. but we did specifically seek their advice in relation to these amendments.
And they didn't come back and say, wow, like FOI is the problem. FOI is what is exposing us to foreign adversaries, did they?
Well, Senator, what they did is provide us with some advice, and I have said to you that some of that advice is of a classified nature, and what they did do is agree with us what they were comfortable with us saying in an open forum, and that's all I can continue to say.
Yeah, no, and what they say is, and it's there in that document, what we can say through consultation with the NIC, National Intelligence Community, is that it's not uncommon for foreign adversaries to identify legitimate avenues or processes, such as FOI, through which to obtain seemingly innocuous information to paint an intelligence picture and use it in ways that are contrary to our national interests. So that's quoting from your email. Is that a fair reflection of the advice?
That's right, Senator, and Mr McClintock has just given me the document, so I have it in front of me. I think then the third dot point says, knowing who we are dealing with through the FOI system by not allowing anonymous requests may go some way to deterring this type of activity. So I mean, I think that the points are trying to reflect that the consultation has happened, there is some advice, and that it may go some way to deterring that type of activity.
And FOI is one of a whole bunch of different, to quote your email, legitimate avenues or processes that may be used to potentially build a mosaic and provide information about Australia to foreign adversaries. That's what that document says, isn't it?
I think that's fair, Senator.
Sorry, Senator Shoebridge, for the interruption. Can I ask that you table the document that you're talking to? I can see that the officials have got it in front of them, but useful for maybe other committee members to have it as well.
I've got a digital copy here, which is part of a long scree of other documents, but I'm more than happy for the officials to table it there, so as we've all got the document in front of us, if that might be the most efficient way.
We can provide it to the Secretary.
No, I think it's actually good practice if it's the Senator who referred to it in the first place to provide the copy via email to the committee, as other senators have prior to tabling their documents. Sorry, Chair.
Is there a single page copy of it?
Tell you what, I will share with you. I'll share to the WhatsApp group right now. Took a little photo of it.
Thank you.
You can all have it. Enjoy. So what are the other legitimate sources that we might then have to shut down once we shut down FOI? We'd have to then shut down newspapers, social media, maybe the Guardian website, the ABC website. Once we start going down this process of shutting down legitimate avenues and processes for obtaining information in FOI, where does it end? Did the National Intelligence Community suggest an end point to shutting down information flows to protect this kind of information?
Well, Senator Shoebridge, we're here and responsible for the Freedom of Information Act, and that's what I'm able to respond to today.
All right. So they didn't identify what would be next on the target list for publicly available information to keep us safe.
Well, Senator, I mean, the points talk about government information, but as I've said, the context in which we were consulting them was in relation to the Freedom of Information Act and reforms to that, and that's our area of responsibility.
It's been hard to identify where the idea for this bill came from inside government. I think in estimates, I asked whether or not it came from Attorney Generals, and we got at best an ambiguous response, but I'm more than happy for you to clarify that here. But while clarifying that, was Prime Minister and Cabinet, were they driving this or part of these reforms?
Senator Shoebridge, I don't think I've got anything in addition to add to what the advice was at Senate estimates.
But this is all just not me, Gov. Wasn't me. Home Affairs says it's not them. Service Australia says it's not them. Is the AG's department saying it's not me, Gov, as well? Is that where we get
Senator,
to?
as I've outlined for you, the department and of course the Attorney General through the Administrative Arrangements Order has responsibility for administration of the Freedom of Information Act, and therefore this department has been the agency who has developed the legislation. But I don't think that's unusual.
But where did the ideas come from? This sort of increasing exemptions for cabinet in confidence, removing access to deliberative documents. Where did these ideas come from? Did those two ideas come from within the Attorney General's department, or did they come from PMNC, or did they come from another agency?
Senator,
can you tell me where
Thanks,
those
Senator Shoebridge. I'm just going to interrupt for a second to say I'll need to rotate the call after this question, but the officials are free to respond.
Yeah, so we're dealing with those two.
So Senator, in terms of
the exemptions for cabinet incompetence and expanding the exclusions for deliberative processes, which agencies did those two ideas come from?
Well, Senator, what I would like to say is in broad terms in the development of this legislation, there were three key areas that we as a department utilised in order to develop what has become the bill that's before the committee. That is a number of reviews that have occurred over a number of years, so I think there are more than 6. We looked at those reviews, their reports, and where available, submissions in relation to those inquiries. We also undertook consultation across the Commonwealth, and that included with the OAIC. And then finally, we undertook a kind of jurisdictional analysis across state and territory jurisdictions, and then like-minded, international comparators in the development of this legislation.
Perhaps I
could
get my question answered on notice, rather than me bounce back and forth and point out how that didn't answer my question. I did ask about which agencies these ideas came from. So could we get that answered on notice, please?
I'll take that on notice, Senator.
Thank you, Senator Shoebridge. Senator Pocock.
Thank you, Chair. Thank you for your time here this afternoon. The bill was introduced on the 3rd of September, and earlier we heard evidence from the OAIC that they saw the bill in full for the first time on the 30th of August. That's 2 business days before it was introduced. Why were they consulted so late in the piece?
Senator, thanks for the question. I think the evidence that I heard was that they were consulted throughout July and August, and then they saw the final version of the bill at the end of August.
The thing they actually said to us is that they were consulted on sort of discrete parts of it in July, and then the first time they saw the bill in its entirety was 2 days before it's tabled in Parliament. I mean, it's sort of like, surely that isn't consultation.
Well, Senator, I mean, there are different ways that bills come together, is what I would say. The OAIC, as I understand it, but my colleagues will correct me if I'm wrong, were consulted on each of the different measures over that period of time that they advised, and then they saw the entirety of it on that date that they provided.
Okay. From what I'm hearing, there's 2 very different conflicting sets of evidence here. One is that there was discrete consultation and then a full bill presented. You're saying that you consulted them on everything. Is that correct?
Senator, I don't think it's conflicting advice. I think what I'm trying to say is that there are different ways that legislation and bills are developed over time, depending on the way things are issued to the Office of Parliamentary Counsel. Sometimes, while you're developing a bill, that's all done in one spot as you go, and so the bill, if you like, is being progressively updated. In other situations, like this one, there are discrete measures, and then that's packaged at the end. It kind of is a bit dependent on the particular measures, what's coming forward, and then the kind of availability, if you like, of the Office of Parliamentary Counsel.
Sure. Given OAIC, you'd think when it comes to freedom of information, the system would be the first port of call. They only saw the bill in its entirety 2 days before it was introduced. I'm guessing that the idea didn't actually come from them, and so I'm interested to press on the questions that Senator Shoebridge was asking. What did prompt the drafting of this bill? Where did that instruction come from?
Well, Senator, I think that what I will say is that the government sets its priorities of the day, and then the job of us, of the public service, is to support government in delivery of its priorities.
But which department did that come from? Did that come from PMC? Did it come from PMO maybe, or was it AGD that decided we're going to reform FOI?
Well, Senator, I think you're not going to be happy with me, but I just have to repeat the answer I provided.
Do you know?
But government.
Do you know the answer to this?
Point of order, Chair. I think Senator Pocock should be giving the witness the opportunity to answer the question. I think this has been prosecuted all day, and so if you could rule on that to allow the official to answer the question and for the interjections to stop so that she can.
Chair, the standing orders say that if an official knows the answer, they must either provide it or claim some sort of public interest immunity. So
she hasn't made either of those claims, Senator Pocock, but you're not giving her the opportunity to answer the question. So I've asked the Chair to rule in favour of that, and it's not against the standing orders for me to raise a point of issue or a point of order.
I think we can let the official finish responding to her answer.
So,
Thank you.
So, Senator, as I said, the government sets its priorities. Our job is to assist and support with the delivery of those priorities. The legislation handbook outlines the process that needs to be followed for the development of a bill. That includes where things need to go through a cabinet process or where the Prime Minister needs to sign off on something going through those processes. What I can say is that these processes have been followed in relation to this bill.
Sure, but to my question earlier, do you know where this request to start drafting this bill came from?
Specifically?
Which department?
I'm not sure that I have that information in front of me, Senator, but I could take that on notice for you.
Do you have it in your head?
Well, I have in my head that we briefed the Attorney General, in a range of different forms and contexts, and I know roughly from when that happened. So, I have that information, but as to the specific point in when it was requested and where that came from, I'd have to take that on notice, Senator.
I guess from where I said this is sounding like a very political bill, if it doesn't seem to actually be based on real problems and evidence and reviews. Every review that you've mentioned basically says, yeah, these changes should be made, but what we need first is a comprehensive review of FOI, and we've got a government that's basically plucked some recommendations and provided a bill to the Parliament. Earlier I was asking the APSC whether the expansion of the Cabinet confidentiality exemption can be justified on the basis that it will promote frank and fearless advice. Their evidence is that they did not consider the exemption and it cannot be. Do you agree?
Could you just repeat that last bit for me, Senator?
So I asked the APSC if expanding Cabinet confidentiality would promote or allow public servants to provide more frank and fearless advice. And they said, no, we haven't even considered that. Do you agree?
I think, Senator, that what we have to point to in relation to that is the government's response in relation to the Royal Commission concluding observation, and in relation to that recommendation where they didn't accept the closing observation, as I understand it, the government said that part of having the exemption in place was ensuring that the Cabinet, the key decision-making body of the government, is comprehensively informed of its deliberations, of which the benefit of frank and fearless advice is required.
But the APSC disagrees with that. From what I hear, that's not actually a factor, because as a public servant you have a responsibility to give frank and fearless advice.
I agree that we have that responsibility, and I thought the evidence that I heard confirmed that we have that responsibility, Senator.
So why are we saying that we need to protect Cabinet documents so that you can do that? That's sort of doesn't make sense.
Well, I mean, I think under the current bill there are two different exemptions. One that one is in relation to the cabinet exemption, and there are some amendments proposed in relation to that. And the second is in relation to the deliberative processes exemption, and including some factors to take into account in the public interest weighing up of whether or not documents should be disclosed or not. And they are, in effect, separate exemptions, and they currently are under the legislation, Senator.
That's final question, Senator Pocock.
Sure, thank you. The Hawke Review has been mentioned a few times. Do you accept that a key recommendation of the Hawke Review was to undertake a comprehensive review of the FOI system? It's page 2 of the review, and I'm happy to quote, "A more extensive review ought to be commissioned by the government to consider in detail the issues raised in this report that require more analysis and those issues that could not be given adequate consideration by the review." Why hasn't this been done?
So we do accept that was a recommendation of the Hawke Review. The Hawke Review made 40 recommendations to improve the effectiveness and efficiency of the FOI system, and that was one of them. Since that time, there have been a number of other reviews, as I think have come up in the evidence previously, including Thodey and Shergold and the 2023 Senate Committee inquiry. All of those reviews were examined in the context of identifying amendments that the government wished to take forward.
But can you just respond to the fact that each of those reviews also recommended a comprehensive review, which hasn't happened?
Well, whether government wants to take a comprehensive review is a matter for government. Government's policy position is to take this bill forward.
Okay, sure.
Okay, thank you, Senator Pocock. Senator Anandaraja.
Thank you, Chair. Thank you, panel. Senator Pocock seems to want us to have death by review, but we are a government that is intent on reform. Can you please, for the benefit of the committee, outline again the reviews, the multiple reviews that have gone on since 2012? Thank you.
Thanks, Senator. I might start and then I might ask Ms Orr to supplement if I've missed anything. I think I said earlier the government had considered previous reviews and inquiries that have been undertaken over the past 13 years, which have commented on the Freedom of Information system. And this includes final reports and, as I said earlier, where available, submissions to those reports as well, or inquiries. These include the OIIC's review of charges under the Freedom of Information Act that happened in 2012. In 2013, there was the Hawke Review into the Freedom of Information Act and the Australian Information Commissioner Act. There was the 2023 Senate Legal and Constitutional Affairs Committee inquiry into the operation of the Commonwealth FOI system. There was the Shergold Review, Learning from Failure, in 2015. In 2019, there was the independent review of the Australian Public Service led by Mr David Thodey. There is the final report of the Royal Commission into the Robo-Debt scheme, and also in 2023 there was the Australian Public Service Integrity Task Force report that was also taken into account. Do you want to add anything?
I can just add that the bill implements a number of the recommendations from the Hawke Review, which concerned, among other things, how to make the system more effective, and the bill implements 8 recommendations in full and 4 recommendations in part from that review. And as has been previously canvassed, the bill also amends the deliberative processes exemption, and this draws on the 2015 Shergold Review and the 2019 Thodey Review, which both explored the impact the FOI Act has on the provision of frank and fearless advice and raised the need for potential reform of the deliberative process exemption.
Thank you. So I counted 7 reviews. I think we've had enough reviews. We need to crack on with reform now. But I also note that the world changes around us, and I just want to draw you out on your concerns regarding artificial intelligence. Can you please outline what concerns you have with respect to the potential for FOI requests to be made without human intervention?
Senator, I think I said earlier that in the opening statement that the operating environment had changed significantly since the Act was first enacted. And I think that, the media release from the Attorney-General in the second reading speech are trying to demonstrate that change in technology over time. And so, it's basic things from email to the use of the internet there are things like web forms and auto-generators, and now what we are seeing in the system and have been advised of is that some agencies are receiving FOI requests developed with the assistance of artificial intelligence. We obviously heard from the Office of the Information Commissioner that they have released some guidance to agencies in relation to requests that are AI generated or might becoming from AI bots, if you like. What we understand is that these requests are often voluminous, they can be difficult to understand, and at times they require multiple attempts at consultation with the applicant to actually understand what it is that the applicant is seeking. And so, I think there is nothing prohibiting people using AI to assist them, but I think that at the moment, the practice that we have heard about is that it is actually at times inhibiting the way that applicants are making those requests, and it's quite challenging to understand the scope of what is being requested. I think the other thing is the bill is trying to have one eye on the future, and so of course right now there is some evidence of AI in the system, but of course AI is developing rapidly. And I think what we have seen in international jurisdictions is clear examples, particularly in the US, where AI tools have been used to generate thousands of requests at once, including to election workers being inundated with FOI requests in the 2020 presidential election. In that situation, it prompted a change in the law in Washington state to allow a refusal on the basis that the request was believed to have come or generated by a bot. So, I think there is international practice demonstrating the potential for AI in the system.
Could we have those references tabled later, please?
We can, Senator. I would say that they have been tabled in the Senate in response to an order for the production of documents. So they are in the Senate already, but we can provide them.
And how would this bill mitigate against the onslaught of anonymous AI bots? Do web forms help, for example? Identification, people having to actually provide identifiers, would all those sorts of measures assist?
That's right. So the bill has amendments that would require the provision of a name as part of a valid FOI application, and the provision of identity in respect of requests for personal information, or allow an agency to request identity in other circumstances. And we consider that would assist with this issue.
Okay, thank you. And my other question, I know there's been some discussion about the cabinet exemption. Can you please outline the rationale for the changes to the cabinet exemption?
Thanks, Senator. Just find my page. Senator, I might start and Ms. Orr, you can jump in if there's anything. The cabinet exemption is being amended to clarify its operation and to ensure that it appropriately protects information central to the cabinet process, and that the principle of collective ministerial responsibility is not undermined. That's in its broadest terms, Senator, what those changes are intended to address.
And I know we're getting into the weeds here a little bit, but it was raised earlier. You did mention the deliberative exemption. Can you please explain how the current deliberative exemption works in terms of balancing various factors? Noting that I am not a lawyer.
Senator, did you ask for us to explain how the current Act works and then what the amendments are proposing to do?
Yeah, that would be great. Thank you.
Sure.
So the amendments provide greater statutory guidance in respect of the harms that the deliberative process exemption is designed to protect. The public interest test in the FOI Act currently provides factors favouring access in the public interest at subsection 11B3 and factors which must not be taken into account at subsection 11B4 in relation to all public interest conditional exemptions. However, it does not currently include factors which weigh against access, although agencies may put forward such factors in making claims of the exemption. The amendments in the bill codify what factors are relevant to consider that weigh against the public interest of disclosure. In specific terms, The amendments will insert new factors into the public interest test to make it clear that they are relevant, and these include where giving access to deliberative material would or could reasonably be expected to prejudice the frank or timely exchange of opinions between participants in a deliberative process of government, prejudice the frank or timely provision of advice to or by an agency or minister, or prejudice the orderly and effective conduct of a government decision-making process. I think, as we've mentioned, this follows some recommendations in previous reviews. I think it's important to recognise that it will remain a conditional public interest exemption, and a decision maker will still need to weigh all relevant factors in coming to a decision.
And I just want to close out on some of the efficiency measures and also the application fee. Can you talk us through about, the rationale for imposing an application fee?
I think, as we've heard through evidence to this committee, there's been an increasing volume of FOI requests and increasing costs to government. The government has decided that imposing an application fee will both assist in terms of managing these issues and also in deterring vexatious requests. It follows a range of review recommendations that consider different forms of application fees. But I'll stop there. And sorry, what was the second part of your question? The efficiency measures?
The question, if you could just step us through some of the efficiency measures. Obviously, we want to save taxpayers money and reduce government waste and any other problems. So, yeah, and of course, dial down any abusive process. So if you could just maybe step us through some of the anticipated efficiency measures that this bill would contain.
Senator,
succinctly would be appreciated. We've need to move on to our next witnesses.
The one thing I just wanted to add in relation to fees before Ms Orr addresses the question around efficiencies is that all other Australian jurisdictions except the ACT do have application fees for FOI requests, and they currently range from about $30 to $57, $58. So I just wanted to make sure that was clear as well, Senator.
Thank you.
And for completeness, the fee wouldn't apply to requests for personal information. But I'll go on then just to talk about some of the efficiency measures in the bill, which include allowing for agencies and ministers in the OIC to specify the manner of electronic communication in which an application can be provided, which will allow agencies to put in place more efficient mechanisms for receipt of FOI requests. Empowering agencies to more efficiently deal with vexatious requests that can divert resources from processing requests made in accordance with the objects of the FOI Act. Streamlining the extension of time, arrangements that can be agreed with an applicant, clarifying that an agency and minister must continue to process a request to make a decision even if the statutory timeframe has passed, which is anticipated to reduce the deemed decision caseload of the Office of the Information Commissioner. The option for an agency to use the discretionary 40-hour cap for processing requests, being able to refuse requests for documents that would be exempt on their own terms, and in addition, a range of measures that will support the efficiency of FOI review decisions. I think the Office of the Information Commissioner gave some evidence about amendments that they had requested, such as preventing concurrent internal and IC review, allowing Information Commissioner reviews to resolve by agreement between the parties without a formal written decision by the Information Commissioner, preventing third parties from automatically being party to IC reviews without limiting their ability to be joined as a party, amendments to enable the OIC to handle complaints more efficiently, inclusion of a remittal power for the Information Commissioner to remit matters to an agency, and ensuring the Information Commissioner review ends when a practical refusal decision is considered by a Commissioner that it does not exist. So they're just a range of the measures.
Thank you very much. Thank you, Chair.
You. And thank you to the officials on the Attorney General's Department for taking time to give evidence to the committee today. Additional information that you've agreed to take on notice, can you please provide that to the Secretary by the 24th of October? And as is usual, you'll be sent a copy of the transcript of your evidence and we'll have an opportunity to request corrections to any transcription errors. Thank you very much.
Thanks, Chair.
I understand our next witnesses are joining us online, so we can move straight into our next witnesses. And I now welcome representatives from the Centre for Public Integrity. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, would you please state your full name and the capacity in which you appear today?
Sure, Chair. Catherine Williams, Executive Director, the Centre for Public Integrity.
Professor Gabrielle Appleby, the Head of Research at the Centre for Public Integrity.
Thank you very much. Do you have an opening statement?
Just a short one, Chair, yes.
Thank you very much.
Thank you. Freedom of information is a fundamental democratic right. In the absence of a pro-disclosure culture, it facilitates the transparency upon which accountability depends, enabling the work of the Parliament, as well as enabling public interest journalism to perform its role in our democratic system and giving meaning to the right to vote that Australians exercise at election time. We are deeply concerned by the FOI Amendment Bill that is the subject of this inquiry. From a process perspective, there has been no public consultation, no real evidence presented to the Parliament and the public to justify its provisions, no attempt to deal with the user experience problems that we know are plaguing the system, and to our knowledge, no impact analysis by the Office of Impact Analysis. When we turn to the bill's substance, we see a winding back of Australians' right to access government information without precedent. Our key concerns relate to the change to the Objects Clause, the expansion of the Cabinet secrecy exemption, the so-called clarification of the deliberative process test, the banning of anonymous applications, and the reintroduction of application fees. Because of its seriously regressive provisions, and also the failure of process surrounding it, our view is that this bill should be withdrawn, and in its place there should be established an independent and comprehensive inquiry into the FOI regime. Thank you, Chair.
Thank you very much for that brief opening statement at the tail end of the day. We'll proceed to questions and go to Senator Collins.
Thank you, Chair, and thank you very much for your testimony today. I was just wondering, Dr. Williams, do you consider the bill should be passed in its current form?
Thank you, Senator. No, our strongly held view is that this bill should not be passed in its current form. It would constitute, really, when we say a winding back, an unprecedented attack on the right of Australians to access information held by their government, particularly via the Cabinet secrecy exemption and deliberative process test expansion. It makes no effort to deal with the problems that users experience with the FOI system. It's entirely one-sided, dealing only with government concerns. It cherry picks from the previous reviews that it purports to rely on. And so for those reasons, no, our strong view is that this bill should not be proceed. There does in its place need to be an independent and proper review of the FOI regime.
Thank you. So you would agree that it should be rejected in the Senate?
We do agree that it should be rejected in the Senate.
Thank you. And what impact will the expansion of the Cabinet exemption have?
The expansion of the Cabinet secrecy exemption would have the effect that a much broader range of information would fall within that exemption, because the change to the words the dominant purpose to a substantial purpose is a very, very significant change. And that, particularly coupled with the change to the Objects Clause that perhaps Professor Gabrielle Appleby can speak to further, will have the effect that less information is going to be released by government. And of course, this comes in the context of some analysis we did earlier in this year around July, looking at performance of this current government on freedom of information that showed us a really concerning metric that outright refusals are increasing. So we, in that context, are particularly concerned about what the impact of the Cabinet secrecy expansion would do.
Thank you. Are you also concerned by the fact that under this bill, departments will be able to refuse FOI requests without even searching for them if it is apparent from their request that it would be covered by an exemption?
Yes, we're very, very concerned. It's another provision that we're very, very concerned by, yes.
Thank you. And what impact will the expansion of the deliberative documents expansion have? Bless you. Coughing. Somewhere in between.
Yeah, thanks, Senator. I'm sorry, I'm quite unwell. I might ask Professor Appleby to answer that for me. Sorry.
Sure.
Yeah, look, we had a number of concerns about the amendments to the deliberative processes exemption. The first concern is that we see it as representing an expansion of the exemption, the insertion of now express factors where giving access could be seen as against the public interest, including prejudicing frank and fearless advice and the orderly and effective conduct of government, which is very broad, right? So it represents a broadening of the exemption. But it also inserts an ambiguity and a lack of clarity into the exemption. So there are existing factors that state when set of factors favouring access and irrelevant factors in the Act. And now you have this whole new set of 3 factors. And how do they sit as against the existing factors? So there is actually an ambiguity and a lack of clarity that's introduced with this exemption, which is going to mean disputes as to the interpretation of the provision, and that's going to lead to longer delay. It's not a clarifying provision at all.
Thank you, Professor. Final question here. Do you believe that this bill is consistent with the pledges that the Labor government made in opposition to be transparent and accountable and committed to open government?
No, we see this as a serious affront to transparency and accessibility of government information in a number of respects. And that's why we're calling for the withdrawal of the bill in its entirety and a full review that looks at how you can promote transparent and accessible government in a modern democracy, not the reforms in this bill.
Thank you so much for your testimony, and thank you, Chair.
Thank you, Senator Collins. Senator Pocock.
Thank you, Chair. Thank you for your time late on a Friday afternoon. Today we've heard government senators put forward a position that we've already had a heap of reviews. I think earlier Senator Cox said that we've already had 5 reviews of the FOI system and another review is not justified. And to quote Senator Cox, do we really want to keep having review after review and never solving this issue? And then a moment ago, Senator Nandaraja said that there'd been 7 reviews. And I'm interested in your response to the argument that, well, we've had reviews and so now it's time to just change the FOI system.
Yeah, look, thank you very much, Senator, for the question. We have meticulously looked through all of the reviews that the government has indicated that it's relying on. One of the key reviews it relies on is the 2013 Hawke review. Now, there's a number of points in relation to that. One, it's a 2013 review. We know how far technology and AI in particular has progressed since then, so it is largely an outdated review. But in any event, its main recommendation, not just one of the recommendations, its main recommendation was that a comprehensive review of the FOI system be undertaken. So surely 12 years later, there is an imperative for such a review. The other reviews that are referred to by government, particularly the 2015 Shergold review, the 2019 Thodey review, which it's relying upon for the expansion or change the deliberative processes exemption, whilst they do talk about their concerns with that exemption, both of those reviews note the need for a further analysis and review. The Shergold review talks about how placing restrictions on FOI is extraordinarily sensitive and the government needs to undertake a thorough assessment. The Thodey review refers to, in Recommendation 8, government to commission a review of privacy, FOI and record-keeping arrangements to ensure they're fit for the digital age, to support greater transparency and disclosure, simpler administration and faster decisions, and B, for exempting materials prepared to inform deliberative processes. They're calling for a further review. They weren't calling to move directly to these changes. And the need for this further comprehensive review was noted by the government members themselves in the December 2023 Senate Standing Committee report on the FOI system, and the government members recommended that the Hawke Review's primary recommendation be considered. That is, the government members said, look, yes, there are problems with the FOI system, which I think everyone universally accepts in their submissions and their evidence to this committee. But let's undertake a proper review. I just make just one further point in relation to this. The government has conducted further consultations. We have heard that the government has consulted with departments and agencies. There's been what appears to be quite a tail-end consultation with the OAIC based on their evidence today, but there has been no further consultation with the users of the FOI system, with the Australian people who the FOI system is supposed to serve. So the government has done further consultation, but it hasn't done full public consultation.
Thank you.
Final question, Senator Pocock.
Okay. I might go to just looking at submissions for this bill. It's basically friendless. I think we've had one witness, the CPSU, suggest that part of it could be carved off and potentially passed. I'm interested what your view is on this bill. Could it be salvaged with amendments, or should we really be rejecting it in the Senate and sending the government back to the drawing board?
Thanks, Senator Pocock. This bill can't be salvaged with amendments. There are some provisions that do some tinkering to deal with some of the administrative burden of the system, but they in no way deal with the structural provisions that really desperately require reform. So no, this bill, regrettably, is one that cannot be salvaged. It has put FOI reform on the agenda, so now there's an opportunity to seize the moment and embark upon the independent review that would address the concerns that government has raised, but also the concerns that users know exist in relation to the system.
Thank you very much. Thank you, Chair.
Thank you, Senator Pocock. Senator Shoebridge.
Thanks, Chair, and thanks to both of you, Dr. Williams and Professor Appleby, for all of your research in the space. You have done some research on transparency, and of course FOI is just one part of government transparency. What does your research show you about the overall transparency record of the Albanese government, say, as against the Morrison government?
Thank you, Senator. Our research raises significant concerns about the Albanese government's performance on transparency via FOI analysis, as you say, but also via performance in respect of compliance with Senate orders for production of documents. So what we see is that there has been a decrease in compliance, but also an increase in reliance on public interest immunity to justify that non-compliance. And of course, I don't need to tell all of you as senators that there is no independent arbiter of these claims. To use the words of a former clerk of the Victorian Parliament, this situation means that the government is in effect the sole arbiter of the validity of its own PII claims. And so in the context of an increase in the proportion of cases where that is claimed, it's deeply concerning. And then there's this kind of more general environment of secrecy where we see, for example, the Linnell Briggs review, which is a review commissioned with taxpayer money, commissioned in February 2023. We understand it was provided to the government in August 2023. The government had committed it to it being released on public websites by December 2023, and the document has still not been released. And this is on a relatively confined issue, the issue of public sector board appointments. Yet we see when there were efforts to get it released in the Senate via the OPD process, the government continues to claim that it's subject to cabinet deliberation. Now, this is 2 years on. So the performance is deeply concerning.
Yeah, and then if this bill goes through, what would that do? Would it put the government on a better path?
No, we don't think that this bill would put the government on a better path towards transparency. It's the exact opposite of what is required to achieve greater transparency. And we're dealing with a fundamental democratic right. The right to access information is a fundamental democratic right. And so what's happening now with this bill is that the government is asking the Parliament to restrict that fundamental right in the absence of evidence. So no, it won't improve the current situation.
Now, we had the Attorney General's Department repeat its assertion that this review, that this law reform that they've put forward is based upon previous reviews, including, I think, Hawke, Shergold and Thodey. What does your understanding of those reviews tell you about that assertion by the government? Do you think this is in any way a fair-minded implementation of those reviews?
Perhaps I can speak to that question, Senator. I've already outlined in detail in response to Senator Pocock's question about the primary recommendation of the Hawke review in particular, the need to undertake a comprehensive review, and that being repeated in the other reviews. But I would also point out that one of the serious concerns that we hold with the reliance on these earlier reviews is the cherry-picked nature of the reforms that have been put forward in this bill. Not just not addressing the call for a comprehensive review in the Hawke report, but in fact the Hawke review was at odds with the views that were put forward in the Shergold and the Thodey reviews in relation to the need to expand the deliberative processes exemption. In Hawke's view, he did not see that FOI was an inhibitor to the provision of frank and fearless advice, which is in contrast to the Shergold position and a position that was picked up by Thodey. We know from his writings, Andrew Podger, a very distinguished former senior public servant and former Public Service Commissioner, agrees with Hawke. So why has the government chosen to go to the Shergold and the Thodey reviews on this issue and not to the Hawke review? We see the cherry picking. One of the most concerning cherry picking is in relation to the Robo-Debt Royal Commission, and I know that other witnesses have spoken to this as well, but we see a claim that the change to the Cabinet exemption is implementing a recommendation or a proposal in the Robo-Debt Royal Commission, where in fact that is not the case. The Robo-Debt Royal Commission provided evidence, which is very rare in this situation. There's often not evidence, as we've heard today, that in fact when there are Cabinet exemptions that apply, we don't see public servants providing robust, frank and fearless advice. There are other deeper structural issues at play as to why public servants are not providing that advice, and it's not because of FOI, the possibility of an FOI request. It's because of issues in relation to appointment, tenure, careerism. But the Robo-Debt Royal Commission, so its recommendations were there be a change to the Cabinet handbook as to how to classify Cabinet documents. So just stamping a Cabinet document does not make it a Cabinet document. Now that small change is put in this legislation, but it also recommended then the complete repeal of the blanket Cabinet confidentiality exemption and to leave in place the public interest balanced conditional exemption of deliberative processes. But what do we see here? We see the expansion of the Cabinet exemption and the expansion of the deliberative processes exemption. Really deeply concerning use of previous reviews.
And for myself, having been part of the 2023 Senate inquiry and recommendations, to see just how cherry-picked that is, I think 15 recommendations and at best 1.5 being implemented and the rest contradicted in their report. But I'll probably just leave it there because I've run out of time.
Thank you, Senator Shoebridge. We'll take that as a statement. Senator Cox.
Thank you very much, Chair. Thank you both for joining us. I know that we'd hoped to have you in our first panel this morning, so it's unfortunate that you were unavailable, but thank you for making time. Doesn't matter how late in the day it is on a Friday afternoon, so welcome to both of you. Were you both involved in the submission to the committee? Yes.
Yes.
I believe that this submission was made in good faith.
Yes.
Yes.
You do? So I'm going to take you to page 2 of your submission, refer to your July 2025 report titled Freedom of Information, Secrecy and Delay.
And in page 4 of that report, you say the rate of secrecy within the FOI regime has sharply worsened under the Albanese government. One of the most concerning trends were identified in 2022, the declining rate of full disclosures and arguably improper use of exemptions has only accelerated. Now, in the footnote that was added to page 5 of your submission, on 22 September 25, it says that you used the AIC's 2022-23 annual report to gather those statistics. Is that correct?
That's correct, Senator, yes.
So you used the statistics, but you didn't use the comments by the AIC on page 45 about the change to its guidance to agencies. Is that correct?
That's correct, Senator, because that comment is not
so that's cherry picking. Sorry, I'm going to keep going. The OAIC's comments on page
Point of order, Chair.
basically say that it can be read into...
Senator Cox, we've got a point of order here.
Just for consistency, maybe we can let witnesses answer before we cut them off.
Sure, thank you, Senator Pocock.
Senator Pocock, it was a statement. So, Chair, I'm hoping to move on. I know we're short on time.
I think, did the witness have something that she wanted to add before Senator Cox continued her question briefly?
Yes, I did want to complete my answer.
Okay, sure.
Is that okay, Chair? Thank you. So,
sure, yeah.
Thank you. So what I wanted to say in respect of that is, so the OAIC says that at the end of 2022, it made a clarification to agencies in respect of reporting. And then they say that in some cases, agencies had recorded decisions in which irrelevant information was deleted as granted in full. So the impact of that clarification is entirely unknown, and that's why we rely on the only figures publicly available to show the government's approach to transparency in that report.
So you use that, the OAIC's comments, basically, on page 45, that says little can be read into the decline and requests granted in full because they actually changed how their reporting was done to being granted in full versus being granted in part. Were those comments actually taken into account when you prepared your report?
Can I just, as a point of clarification, Senator, indicate that the OAIC's report indicates that it's not a change in reporting, but that it's not a change in the guidelines, but that it's a clarification. And that's what the report says. And that because of the clarification, some agencies might have changed their practice in reporting based on it. So that is what's in the OAIC's report as to what the changes were from the OAIC's.
I think the point I'm trying to make, Professor Appleby, is you're trying to use this to justify your claim that the FOI regime has worsened since 2022, when actually it says that in the same report that you rely on in your data, little can be read into this change. You're actually trying to draw a really long bow that the Albanese government's transparency then is the worst that it's ever been on record, when actually you failed to correct that. The footnote that you added to your report to this committee was actually added on the 22nd of September, more than a month after you published your report and 2 days after you made your submission to this committee. Why was the footnote added on the 22nd of September 2025? Why was it not corrected soon after to clarify this? Why did you wait? Or did you just cherry pick that? I'm still without an answer about, there's a footnote here that's outstanding. You've submitted to this committee. You've chosen to only include the relevant information that you wanted to base your claims against the Albanese government, and yet they basically then fail in your public media statements and your commentary, which has been very, very misleading, and your own report. Can you please tell the committee about why you actually did that?
Well, Chair, I do have a point of order. That wasn't a question, and it wasn't a fair question. It was a prolonged attack on the witnesses. Let me finish.
It's my question, sorry.
Please let me finish.
All right.
And it's contrary to what your introductory position was about treating witnesses with courtesy and with respect. And I'd ask you...
Well, you're not the chair of the committee.
Sorry, Senator Cox.
And
just
so,
reflect upon...
again...
Just reflect upon...
I'm not going to take lections from you. Sorry, not going to...
Sorry, if we can just take a break for a second.
If you can reflect upon the opening statement and treating witnesses with courtesy and respect.
Again, not taking lectures.
Senator Cox, we have a minute left for today, so if the witness can respond to Senator Cox's question before we finish up for the day.
That'd be helpful. Thank you.
Well, we stand by the quality of our research. As I said, these are the only figures that are publicly available that can be used for this kind of analysis.
Okay, my final question, because I know that the chair wants to wrap up. Do you commit to correcting your report and your public statements in light of this to ensure that, in fact, there is no cherry picking and that you provide clarity to your statements to ensure that this is not disingenuous about its reflection?
Senator, it's our view as researchers that no clarification is required.
Thank you very much. That concludes all the time we have today for this hearing. I want to thank witnesses for their time this afternoon giving evidence to the committee. If you've been asked to provide any additional information, would you please provide it to the Secretary by the 24th of October? You'll have an opportunity to request corrections to transcription errors as well. Thank you very much. I'll thank Hansard and the Secretary for all of their work in supporting the proceedings today. Before we conclude, I'll ask that a Senator move that we table the document provided by Senator Shoebridge earlier today.
Chair.
Thank you, Senator Cox. And we'll now adjourn. Thank you very much.
Thank you very much.
Thanks, witnesses.
Thank you.
Thank you.